Sir, quota number 8, is it audible, sir? Hanif? Ravi Kumar?
Yes, sir, it is audible.
Thank you.
Yes, sir, it is audible.
So first submissions will be through VC with regard to any adjournments. After VC submissions, any memos from left to right. After memo submissions, if you are having a request with regard to adjournment, left to right. Thank you.
Hello. Morning. Kenapa?
ಕೆಲಸ ಇದೆ ನಿಮ್ ಕೆಲಸ ಮಾಡ್ತದೆ
Copy of this letter is also sent to GM Mentor on the video.
Yes, sir, Hanif, sir.
Madikeri for his record of
Any mentions through video? Any memos from left side? What is the urgency? I have filed an application for interim relief next week, subject to complaints of the subjection. Yes.
Institution gaps, sales which are 70, how they were saying, serious issues. They trusted their brothers, two brothers and two sisters. They two brothers managed.
What is the stage of the case? What is the stage of the appeal? Fresh appeal. Have you prayed for any interim relief? It's the day after tomorrow. Tomorrow. Yes. Which year matter?
2019, my lord.
Then you have to file an early hearing application. Yes.
Second appeal, the execution proceeding, they are able to take redelivery. Already the case is for the stage of the case is for admission and hearing on IA.
Reporting this.
Have you filed the compromise petition in the registry? File it there. Complies after subjection. Then move the matter. Yes.
Audit was dismissed for non-prosecution. Hence, I filed IA one for restoration for
Who are you?
14%, appellant, Your Honor.
You have been permitted to proceed as 14%.
Okay.
This week.
That is what is for tomorrow.
Mentioning.
Number 68 minutes. Previous time accommodation, Lord, I want to take instructions from the respondent. Previous time. They have confused on their reason.
At the request of the learned counsel for the upper respondent. I finally, a short date as spread is granted, use this matter on 18/7. Yes. 53.
For the respondent, Your Lord.
Yes.
Since office has been shifted, my file is missing, Your Lord. A week's time, my family will do it.
Because of the learned counsel for the respondent. A week's time as spread is granted. Yes.
Serial number 71, my lord.
Yes.
I'm for respondent. Appellant is not a paper book copy. Try to contact the appellant that will pay for time. It's for
Who will
final.
appear for?
I'm for respondent, Your Honor.
Because of the learned counsel for the respondent as finally
Paper
2 weeks
copy is
time
not
as spread is
served.
granted. Yes.
Third time. DDSP Paladare.
Order dated 3/7/23. Review. For non-association non-complaints.
5th time, fill number 2, Jacob City H.
One is fresh, my lord, must be they are regarding certificate copy. Earlier, my valuation slip, I could not get it, my lord. Trying, my lord. Because the succession certificate, we got. All other objections complied.
Those sufficient opportunities have already been granted in this matter, however, considering the reason shown by the for the appellant, final ultimate opportunity. And also, when reiterating the observations made on 3/7/2023, each time is granted to comply all of the subjections. Case of office subjections in their entirety are not complied within the week from today. This matter on April, on which day the court must proceed to pass appropriate source. Yes.
Fill number 3, Sri Vijay Kumar.
My lord. Determination of the jurisdiction matter, it comes on division to expense. Comes to the property values of 85 lakhs.
Submission you are making probably is not directly relevant to the office subjections we are yet due for complaints.
The office subject, I certificate copy has to take the valuation sheet with that. Thereafter, family tree also impose the certificate copies.
And finally telling the submissions probably you are making are not connected to or much relevant to the office subjections which are still open for complaints.
Yes, I mean.
100 rupees per day.
It's ready, I can put this time in.
If everything is ready, you should have done by this time. You have not done. Even after granting several sufficient opportunities of not less than 5 times, or even as final and final instances, the appellant has not completed the office objection. On 28/6/2023, it was made very clear that in case if the office objections are not complied, the court would proceed to pass appropriate order, including dismissal of the appeal for non-compliance. In spite of the same, counsel for the appellant is physically present, makes a submission which appears to be not connected with the complaints of the office objection. As though the appeal could have been dismissed, however, considering his request as an ultimate opportunity, 3 days time is granted to comply of his objection, however, imposing a cost of ₹200 payable by the appellant to the legal services committee of this court during the course of the day and filing a complaints memo along with the original receipt to that effect in the registry within the set time. In case if the office objections are not complied after paying the cost, within 3 days from today. List this matter on 18/7, on which day the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. Yes.
Number 4, Evi Muralidhara, 6th time, non-compliance.
My lord, I may kindly be permitted to withdraw this. Last time I had paid for that. I request this honorable court to permit me.
The conflict for the appellant is physically present. That is submission on it. Not complete. 500 so on. Technically, without the. Okay. Counsel for the appellant makes a single. Permit to. There is the company in the idea. Doing the affidavit, several other things are also being stated, but they do not deserve any observation by this court. See, the application is being withdrawal of the assessed without in observation. Actually, reading para 1 to para 7 of the affidavit. It stands. This means that's not. Yes.
Number 5, Vasant Kumar.
You cannot substitute a memorandum of appeal with another one. Whatever the corrections are there, permitted corrections are required to do in the original appeal memo itself. It's only with the leave of the court. You can substitute it with a neatly typed version. On your own, you cannot. So the
Votes, my lordship. I added a valuation thing. And there was a constable correction was there, my lordship. Regarding the defendant number 20, my lordship.
what the court said properly, you have not followed. Without the leave of the court, you cannot substitute the memorandum of appeal.
Yes, my lordship.
You have done it. Despite the court repeatedly telling the learned counsel for the appellant that this, without the leave of the court, we cannot substitute a memorandum of appeal. The learned counsel stands quite without making any submission. Matter stands passed over.
Order final, still number 6, tender over TS, GM Srinivas Reddy for respondent.
Was missing. So we comply the officer. Next time. The respondent was represented by manager in the trial court manner. ಅದು ವಕಾಲತ್ತಲ್ಲಿ ಇದ್ದಿದ್ದು ಬೇರೆಯವ್ರ ಸಿಗ್ನೇಚರ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು ಅದು ಫೈಲ್ ಎಕ್ಸ್ಪ್ರೆಸ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿ
500 rupees per day. Maximum 1 week. How many days you want to tell me? Learned counsel from both sides present. The learned counsel for the respondent once again prayed for time to comply of his objection. After seeing that several sufficient opportunities have already been granted in this matter, and on 19/4/2023 also the time as sought for was given when the court told the learned counsel for the respondent that granting of any further time would be only on the cost of ₹500 per day. The learned counsel prays for a day's accommodation, hence imposing a cost of ₹500 payable by the respondent to the legal services committee of this court during the course of the day and filing a complaints memo, etc., etc., etc. A day's accommodation as prayed is granted. It is made clear that no further adjournment for any reason would be granted in this matter. The parties to either report the settlement in accordance with law or to proceed further in the matter. List the matter on 14/7/2023. Yes.
Still number 7, Gurraj TN, Archana KM, amicus curiae for respondent number 2.
Respondent.
Counsel for the appellant and the amicus curiae for respondent to four are physically present. That is the delayed payment of cost is accepted. Yes.
May be permitted to take substituted service because the notice issued through court also returned as unclaimed. But the hand summons also we are not able to execute because he was not available in the residence.
For the submission of 11 counsel for the appellant. The appellant has filed a memo dated 4/7/2023, returning the original unserved hand summons issued to the respondent number 1. Except filing the day. Is issued by the court. Appellant has not filed any affidavit or acknowledgement showing copies of the memo or attempt made in that regard. However, the submission of the learned counsel for the appellant makes it clear that the appellant could not serve the appellant did not serve the notice by hand to the respondent number 1. The absence of any reasons in the absence of an affidavit showing the reasons for non-service of notice by hand. It cannot be accepted that a sincere effort was made to serve the notice upon the respondent number 1. Hence, the appeal as against respondent number 1 stands dismissed for not taking step. In view of the same, the maintainability of the appeal as against the remaining respondents alone is required to be heard at the appropriate stage.
I have filed an affidavit the last occasion, that is on 3rd June 2023 when I have filed affidavit.
Bill number 8, Revena Bellari, Kalimala Sharif for respondent number 1.
Deposit your telephone, please.
Sorry, madam.
Deposit your cell phone, please.
ನನಗೆ ಅದ್ರೊಳಗೆ
Deposit your cell phone, please.
ನನಗೆ ಅಲ್ಲಿ communication
Deposit your cell phone, please.
ನನಗೆ ಇದು ಆಗ್ತಾ ಇಲ್ಲ ಮೇಡಮ್.
Deposit your cell phone, please. Last time I am telling, otherwise contempt would be initiated.
ಅಲ್ಲ ನನಗೆ ಅಲ್ಲಿ ಬೇರೆ
Yes.
ಕಂಪನಿ ವಾಯ್ಸ್
Don't return that without the order of the court.
ಸಾರಿ ಮೇಡಮ್.
Advocate ಗಳಿಗೆ ಶಿಸ್ತಿಲ್ಲ ಅಂದ್ರೆ ಕಕ್ಷಿದಾರರು ಕಲಿಯಲ್ಲ.
I do not
Make submission regarding the case, please.
I do not repeat my lord.
Make submission regarding the
In
case.
this case, my lord, the notice to respond number 7 has been returned without being serving, stating that he is not residing in the address. So that I brought the fresh address and correct address, madam. May kindly be ordered for reissue notice to the respond number 7.
I'll pass over the matter, take substituted service of.
I brought the correct address because he has shifted the residence from the place of the showing earlier address. And even he left the father house.
Sir, several attempts you have made. 6 years are over. 6 years. In the guise of say taking steps, you were successful in seeing that say the matter has not been gone to this next stage for 6 years. You have done your effort. Yes. Take the substituted service of notice. Will pass over. That is possible to enable the learned counsel for the appellant to take the substituted service of notice upon the answer. Respondent number 7.
Serial number 9, K. Srihari, Aruna YM, ML Dayanand Kumar for respondent.
When appearance the matter could not be proceeded.
Then number 10.
Appear for the appellant, my lord. 2 days time be granted, my lord. I'll comply with the office objection. Paper publication application was filed. Only some office objections are there. 2 days time, my lord. I'll comply.
One more 23. At the request of the Learned Counsel for the appellant, a day's accommodation is granted to comply with subsection and I 1/2023 filing which the court may list the matter. 117.7. Yes.
Cell number
Yes.
11, Kapil Dixit.
Appear in this matter either physically or through video conference. It is not known how come the registry has listed the matter. 14/2/2019 when peremptory order was already passed on 18/6/2018. But the registry even did it, the appellant has not filed. Compared office subsection. Neither compared the office subsection nor paid the cost imposed as long back as on 18/6/2018, which is 3 years back. Hence, the peremptory order was on 18/6/2018. Which is the operation on its own automatically registered to take note of the same.
12, Jagdish Acharya. K. Vijay Kumar.
For 2 weeks for.
Both side present. As requested, 3 weeks time is granted to 5%.
Cell number 30, K. Srinivasa.
Counsel for the appellant who is physically present except praying for a week's time. There is no further submission in the matter. There is a of the order sheet to show that in spite of granting several insufficient time, as long back as 36/2022, to take appropriate steps in respect of unserved respondent number 9 and 10 within 2 weeks from said date. Admittedly, the appellant has not taken still date. As such, the appeal as against respondent number 9 and 10 stands dismissed for taking step. The rate of the dismissal of the appeal as against respondent number 9 and 10, the maintainability of the appeal as against the remaining respondents is required to be heard at the appropriate stage. Next slide. Two reasons are shown for not carrying out the amendment permitted 36/2022. It's more than a year now, the appellant has not carried out the amendment. Assessed the registry to carry out the permitted amendment dated 36/2022. In which regard, the cost of ₹1,000 is imposed upon the appellant, payable to the Legal Services Committee of the court within a week from today, and filing a complaint along with original receipt to that effect in the registry within the said time. To ensure the payment of the cost, registry to after ensuring the non-payment of the cost would lead this court to pass appropriate order towards recovery of the cost. Other relevant orders, including dismissal of the appeal for not complying the directions. This is the matter. 1:7.
Number 14, A per D.
I filed paper book also yesterday. I filed paper book, my lord. Deposited cost and paper book was filed yesterday. I have acknowledgement.
Appearance to video conference submits as filed paper with the registry yesterday. Registry to verify and proceed.
Number 15, Vijay Kumar K.
Pray for a week's time. Full response.
ಇದೆ ಟೈಪ್ ಇಲ್ಲ ಕೈಯಲ್ಲೇ ಬರ್ತಿದ್ದ ನೋಡಿದೆ ಹಾಗೆ ಹಾಕಿದ್ರಿ ಬಾಕ್ಸಿಗೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಬಹಳ ಬಿಗಿ ಆಗ್ತೇನೆ. ಚೀಫ್ ಜಸ್ಟಿಸ್ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಇಶ್ಯೂ ಮೆಮೋ ಅಂಡ್ ಪ್ಲೇಸ್ ಇನ್ ರೆಕಾರ್ಡ್, ಅದು ನಿಮಗೆ ಬರ್ತದೆ. ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಗಲಾಟೆ ಮಾಡಬೇಕು, ಅವ್ರ ಜವಾಬ್ದಾರಿ. ಅವ್ರು ಮಾಡಿದವ್ರೆ ನನ್ನ ಮುಂದೆ ಇಡ್ಲಿಕ್ಕೆ ಮುಂಚೆ ನೀವು ನೋಡ್ಬೇಕು. ಫಸ್ಟ್ ಅವ್ರದ್ದು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ, ಎರಡನೇದು ನಿಮ್ಮ. ಹೀಗೆಲ್ಲ ಬರೆದ್ರೆ ಸಂಧಿಯಲ್ಲಿ ಕೂರಿಸಿ ಬರೆದ್ರೆ ಏನ್ ಅರ್ಥ ಆಗ್ತದೆ? Counsel for the appellant present. Handwritten endorsement is not properly legible. Just to get it typed and the counsel from both sides present, 3 weeks time has previously granted the file.
Number 17. Number 17, Madhvacharya and
Well, okay. 2 days time is granted to take fresh steps to ensure the service of notice upon unserved respondent. If steps are not taken within time, list this matter on 17/7, on which the 17/7 first date.
Serial number 18, G. Balakrishna Shastri, A. Vijay Krishna Bhatt, for respondent.
Counsel for the appellant. Await service of notice. Yes.
Serial number 19, 19, Srinivas Raghavan.
None appear for the physical or video conference. Reasons are for non-appearance. Okay, the counsel for 6/11/2019. It was in the cost of rupees 500 payable to the Legal Services Committee of this court. 4 days from the said date, and filing a comprehensive note along with receipt in the registry in that record. An adjournment as sought for was granted. The a week's time as paid was granted. Thereafter, till 4/7/2023, the matter was not listed. 4/7/2023, nearly for 4 years, the matter was not listed. 4/7/2023. The appellant was directed to pay the cost. The Legal Services Committee of the court only in a day from the said date. And to take appropriate steps to ensure the service of notice upon the sole respondent. As a final last opportunity, 3 days time was granted to the appellant to take fresh steps. In spite of the same, the appellant has neither but the first not taken steps as a the sole respondent, nor even appear. The man and shown the reason for not doing needful. Next, the appeal stands a dismissal for non-prosecution as well as for non-taking step. 3. Steps. If the sole respondent is a recovery.
Cell number 20.
Course of the day I will take. So I will furnish IA copies and the copies of appeal.
Those learned counsel for the appellants accuse that during the course of the day he would do needful. However, the case file go to show that in this appeal of the year 2017 till date, the appellant has not ensured the service of notice upon the sole respondent. On 9/1/2023, which time was granted to the appellant to do needful. Since then, 6 months time has been lapsed, still the appellant has not paid the process fee and taken steps in the registry. Though the appeal could have been dismissed for not taking step, but by imposing a cost of payable by the appellant to the Legal Services Committee of this court before the forenoon session and filing a complaints memo along with receipt, etc., is permitted to take steps during the course of the day in the registry. Process to be accepted only after ensuring the payment of the cost. If needful is not done, the matter on 14/7.
Request your lordship. Process is already made. It is for furnishing of IA copies and appeal copies. That's
Process ಅದು ಒಂದು ಪಾರ್ಟ್ ಅಲ್ವೇನ್ರಿ ಬರೀ 25 ರೂಪಾಯಿ ಕೊಟ್ಟರೆ ಮುಗಿಯಿಲ್ಲ ತಾನೆ ಮತ್ತೆ
Cell number 21. Balaji Raghunathan. Arune Gadak.
none appear for the appellant either physically or through video conference or responsible for the respondent alone. Which respondent to appear? Physically present. There is the memo of retirement filed by the appellant. Admittedly, there are more than one appellant in this matter. Except appellant number 1, the remaining appellant is not shown to have acknowledged either the notice of retirement or the retirement of his counsel. As such, the said memo of retirement stands rejected. In view of the non-filing of the paperwork in spite of granting several and sufficient opportunities, and also for not showing any reasons for non-filing of paperwork, the bill stands dismissed for non-prosecution as well as for non-filing.
Bill number 22, Chandrakumar R, Harish Bhandari T.
Last occasion, I filed application, take steps to be respondent number 6 to 8, they have substituted steps. It may be permitted with steps. This was done. Address C was left. Respondent number 6 to 8.
Notices conference. Addition of the.
On 36/2023, were granted time to take first steps by ascertaining the correct, complete and present address. You have not taken steps.
They are purchaser, they are not family members to the appellant. Already notice returned as answered address is left on the body. So that's why last occasion itself, I filed application and made submission before the sum. Or parallel application. Substitute service. Address is left on
ನೀವು
the.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ on 30/6/2023 itself, you were directed to take steps once again. Your application was kept pending.
That is, sir. I made submission. May be permitted to file application to take steps to the respondent number 6 to 8, where substitute service. Accordingly, I filed application.
Your submission cannot be taken as a permission by the court. You making submission, you presuming that your submission is the court order cannot be accepted.
Sorry.
You may make 100 submission. They are all only your submissions, not the order of the court. The court ordered on the said day after hearing your submission that you have to take first steps
Address C left
by ascertaining the correct address in the normal course.
address C left ಅಂತ ಬಂದಿತ್ತಲ್ಲ ಹಾಗಾಗಿ ನಾನು sorry.
The IA 1/2023 stands returned to the applicant for not complying the office objection. Though the appeal could have been dismissed, though the appeal as against unserved respondent number 6 to 8 could have been dismissed for not taking step.
During course, I will furnish.
However, considering the submission made today, 3 days time as an ultimate opportunity is granted. If needful is not done, list the matter on 19/7.
Serial number 23, Rajagopal.
Yes.
Lordship, I have received a NOC wakalat last week, Your Lordship. A week time can be granted. And as far as address of the respondent number 3 and 4 is concerned, the survival of the family, Savita, maintains that she doesn't know any alternative address. But still, I'll instruct her to find out the question. And another humble submission is the Putte Gowda, he's died in the IA 2021. It is mentioned that the Savita and Putte Gowda has to be added as legal representatives, but Even the Puttegoda has died in 2020. I'll be filing the
Whom you have filed NOC Wakala?
Rajashekharappa. Last, Savita, Your Worship. Savita. Now only one member is surviving in the family.
Please. Whether the appellant is no more and her legal representatives were brought on record.
As far as the records just given to me by Savita last week, an IA has been filed to add the LRs, Puttegoda and Savita. The
What happened to that IA?
Lordship.
What happened to that IA? Whether that IA was allowed?
Even the copies, the previous lawyer has not given the copies to the other party.
Then why did you file wakalat without obtaining the papers?
They have given the copies of IA to me. Now, as
As a counsel, are you not aware that once the counsel files wakalat, he cannot say pass on the blame to his previous counsel or the party? At the time of filing the wakalat, he should ensure that he has been furnished with all instructions, both oral and documentary,
Lordship asked,
and equip you to proceed further in the matter.
Lordship, I've got the copy of the IA which is filed in 2021, 13/12/21. So as for according to this IA copy, the advocate appellant seeks the permission to add the legal representation. Savita Puttegoda.
Application ತೆಗಿರಿ.
In the name
ಏನ್ ಇಟ್ಕೊಂಡು ಮರಿ ಹಾಕ್ತದ ನಿಮ್ಗೆಲ್ಲ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ಕೂರ್ತಿರಲ್ಲ. ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಅವಾಗಿಂದ ಥ್ರೌಟ್ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಒಬ್ರು ಆಸ್ ಯೂಶುವಲ್ ತೂಕಡಿಸ ಕೂರ್ತಾರ, ಇನ್ನೊಬ್ರು ಕೆಲ್ಸ ಇಲ್ದ ಕೂರ್ತಾರೆ. Alleged LR application, court officer says it's not forthcoming in the court records.
Lordship, it is filed on 13/12/2021. Today it is also instant for transferring the copy to the respondent. And serving, giving the other address for respondent number 3 and 4. An applicant was Srimati Ningamma. Later, Geeta was representing. She died, and after that, an application was filed on 13/12/2021 to add Savita and Puttegoda as a legal representatives. To add as legal representatives.
Whom you here for? Sir, copy of IA to him, please, the LR application. You have any objection on the said application?
In this, Puttegowda is even not surviving now. PV Puttegowda is no more.
Hmm.
We will be filing the death certificate in the office, your lordship. Only Savita is here surviving, means as of now, she is there.
When did Puttagowda die?
2022.
Which day?
I'm not aware of that date. Your lordship.
Learned Counsel. Mr. Sheila Advishaya is physically present. Learned Counsel for the respondents are physically present. Learned Counsel for respondents. Who is physically present? Learned Counsel for respondents are physically present. The counsel for the respondents acknowledges the receipt of the copy of IA 1/21 and submits their no objection to allow you. The counsel for the appellant submits that. Among the applicant in the said IA by name. The Puttagowda is also now dead. According to the counsel. When he died?
2022, as for the information given by Savita, I
According
don't
to
know the
counsel, as
exact
per the
date.
information given to her by applicant number 1 is Srimati Savita. The applicant number 2, Sri Puttagowda, died in the year 2020. In view of the same, the application of applicant number 2, Sri Puttagowda, stands awaited. Collaboration of the list a matter. 3 weeks as yes.
Number 24, Lila Krishnan D.
Apparently, in this case, filing a memo to respect that the action is that is not practiced in the 2021.
ಅಂದ್ರಲ್ಲ ಇಸ್ಕೊಳ್ಳಿ. The counsel for the appellant Sri G. Sanjay is physically present. He has filed his reporting that his co-counsel Sri D. Leela Krishnan has quitted from practicing for the year 2020. Registry to take note of the submission made in the memo and do needful in the matter. Next line.
Only 2 times notice.
They have not taken first steps to respondent number 1 and 2. Application 1 do.
Number sufficient. One number sufficient. Trial court cannot, sir. The 2 persons impersonating me and my son, they try to execute the 50 in my favor. I challenge that 50, the 50. The trial court dismisses my suit only on the ground that I have not with the original sale. Original sale deed was with my husband who was a 20 car and he had kept placed with someone else. At a person came to me after death of my husband in 2021 and hand over saying that see with me, you return my money, I return with the sale deed. No, sale deed is with my custody along with the proof. That is the only sole ground on which the suit is dismissed.
Why you are making all those submissions now when the respondents are not yet served?
That's because in the trial court also, not when the notice was not issued. They said no such person was there. I took paper publication. The person's respondent never existed in that address because they had impersonated me and my son and executed a fake gift. Challenging that, I had filed a suit for cancellation of that gift. My humble submission is not there is the respondent number 2 never existed in that address, not they were ever there. They had impersonated me and my son and executed it. That's it.
I am not only surprised but also shocked to hear these submissions from the learned counsel. Sir, you are an advocate.
Please,
The party may tell you that say the parties, the defendants are not there in the address given by them. But is it not your duty as an advocate to convince them that whomsoever they want to file a suit against, they have to ascertain their address and give the correct address, not fictitious address.
no, the address.
Because you are the plaintiff. You are the plaintiff. You want to sue some person, including making an allegation that they have practiced fraud upon you or impersonated somebody, maybe criminal case or civil case, whatever may be. But to arraign them as party, you should see that they are notified in a manner known to law, that a case, a suit, a complaint has been filed against them.
I shall take fresh steps for us.
No, sufficient time was already granted to you.
That's my humble submission.
No purpose in granting further time.
That's my humble submission. That's one humble submission. The address which was inserted in the gift deed is the address on which I have taken notice in trial court as well as.
ವಕೀಲ್ರೆ, ನಾನು ನಿಮ್ಮ ಸ್ಥಾನದಲ್ಲಿ ಇದ್ರೆ ಬೇರೆ 10 ದಾರಿಗಳು ಇರ್ತಿತ್ತು ಹೇಳ್ತಿದ್ದೆ. I am not your counsel to advise you what to do. But I can only notice that what you have done is not satisfactory to the law.
I shall ascertain the real address once again and take the steps.
I am really sorry. Basic thing, what a counsel is required to do to ensure the service of notice to the defendant as a plaintiff, what are all his obligations and duties? ಅದನ್ನು ಕೂಡ ವಕೀಲರು ತಿಳ್ಕೊಳ್ಳಲ್ಲ, ಬರೀ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಇದ್ರೆ what I should do?
I'll seek the fresh address. I'll try to find out if it doesn't take steps. 1 week may finally be granted.
You know of the non-compliance of objection, IA. 1/21, 1/21 stands for the other. 1/23 stands returned to the applicant. At the request of the learned counsel for the opponent as an ultimate opportunity, a week's time is granted to ascertain the correct, complete and present address of unserved respondent and to take first steps.
Till number 25, Raghavendra K. Ashwin Kumar. For Kevata respondent number 2.
Respect of respondent number 7. Correct it, please. Other response have been served, my lord. Notice has to be issued only in respect of respondent number 7. The address is as furnished in the original suit, my lord. But now it has been written that the person is not residing over there, it's in ask. But may be permitted to furnish correct address and I will be permitted to take fresh steps.
No, if I don't permit, what would be the consequence?
Take necessary file necessary application by taking paper publication.
That is all, say you have understood of CPC.
Is a plaintiff in the original suit.
Don't you have a right to take fresh steps by furnishing the correct address?
That is my humble
Are you
submission.
required to obtain a permission of the court to that effect? Then pray for permission is nothing but if the court can use the word gimmick or a trick to take some more time, that is all. Or ignorance of the law. Whichever you say find it acceptable, you can accept. But ಏನ್ರಿ
I'll furnish correct.
ವರ್ಷಾನುಗಟ್ಟಲೆಯಿಂದ ದಿವಸಕ್ಕೆ 100 ಕೇಸ್ ನೋಡ್ತೇನೆ. 2017 ಇನ್ನು ಹಳೇದೆಷ್ಟಿದೆ ಗೊತ್ತಿಲ್ಲ, ನನ್ ಮುಂದೆ ವರ್ಷದಲ್ಲಿ ಬರೋ 2017 ಇಂದ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಲ್ಲ 25 ರೂಪಾಯಿ ಕಟ್ಟಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ, 25 ರೂಪಾಯಿ, ಓನ್ಲಿ 25 rupees ಕಟ್ಟಲ್ಲ, ಒಂದು ಕವರ್ ಹಾಕಲ್ಲ, ಒಂದು ಅಡ್ರೆಸ್ ಬರೆದು ಎಲ್ಲ ಮಾಡಿ ಯಾವಾಗ್ಲೂ ಪೋಸ್ಟ್ ಆಗ್ತದೆ. ಆ ಮಹಾನುಭಾವರುಗಳು ಕೂಡ ಇಮಿಡಿಯೇಟ್ ಅದನ್ನ ಪೋಸ್ಟ್ ಮಾಡಲ್ಲ. 20 ಸರ್ತಿ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರ ಮೇಲೆ 4 ಕೇಸ್ ಪೋಸ್ಟ್ ಮಾಡಿದ ಶಾಸ್ತ್ರ ಮಾಡ್ತಾರೆ, ಮತ್ತೆ ಮಾಡಲ್ಲ. ಅದೇನು ಅವರಿಗೆ ಆಪಾಟಿ ಕರುಣೆ ಪ್ರೀತಿ ಪ್ರೇಮ ಇದೆಯೋ ಗೊತ್ತಿಲ್ಲ, ಮಾಡಲ್ಲ. ನೀವು ಯಾವ ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಇಮ್ಮೆಟೀರಿಯಲ್, ದಟ್ ಈಸ್ ಇಮ್ಮೆಟೀರಿಯಲ್. ಯಾವ ವಕೀಲರು ಕೂಡ ನಾನು ವಕಾಲತ್ ಮೊನ್ನೆ ಅಷ್ಟೇ ಹಾಕಿದೆ ಅಂತ ಹೇಳ್ಬಾರ್ದು. ಹೇಳಿದ್ರೆ ಅದು ಅವರ ನಿರ್ಲಕ್ಷ್ಯತನವನ್ನು ತೋರಿಸುತ್ತೆ. ಯಾವಾಗ್ಲೇ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ವಕಾಲತ್ ಬಂತು ಅಂತ ಹೇಳಿದ್ರೆ ವಕೀಲರಿದ್ದವ್ರು ಹಿಂದೆಲ್ಲ ಏನೇನಾಗಿದೆ ಕೇಸಲ್ಲಿ, ಎಷ್ಟು ಹಳಸಿ ಹೋಗಿದೆ, ಅವೆಲ್ಲವನ್ನು ನೋಡ್ಕೊಂಡೆ ನಾನು ವಕಾಲತ್ ಹಾಕ್ಲಿಕ್ಕೆ ನನಗೆ ಇಷ್ಟ ಇದೆಯಾ ಇಲ್ವೋ ಅಂತ ತೀರ್ಮಾನಿಸ್ಬೇಕು. ವಕಾಲತ್ ಹಾಕಿ ಆಮೇಲೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾನು ಇತ್ತೀಚೆಗಷ್ಟೇ ವಕಾಲತ್ ಹಾಕಿದೆ ಅಂತ ಹೇಳುವುದು ತರವಲ್ಲ. ಇದನ್ನ ಪ್ರತಿ ಸರ್ತಿ ಹೇಳ್ತೇನೆ, ಆದ್ರೂ ವಕೀಲರುಗಳು ಅದೇ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ. ಅದು ಎರಡನೆಯ ವ್ಯಥೆಯ ಸಂಗತಿ ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ. ವಕೀಲಗಿರಿ ಅಂದ್ರೆ ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕು ಇಲ್ವೇ ಇಲ್ಲ ಬಹಳಷ್ಟು ಜನಗಳಿಗೆ. ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಹಿಂದಿನ ವಕೀಲರು ಏನೋ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರ ಕೇಸ್ ಕೆಡಿಸಿದ್ದಾರೆ, ನಾನ್ ಕೇಸ್ ನಡೆಸಿಲ್ಲ, ವಕಾಲತ್ ಮೊನ್ನೆ ಹಾಕಿದೆ, ಅವೆಲ್ಲ ಒಂದೊಂದು ಸಬ್ಮಿಷನ್ ಏನ್ರಿ ಮಾಡೋದು? ಆಪರೇಷನ್ ಥಿಯೇಟರ್ ನಲ್ಲಿ ಪೇಷಂಟ್ ಮಲಗಿಸಿ ಡಾಕ್ಟ್ರು ಹಿಂದಿನ ಡಾಕ್ಟರ್ ಏನೋ ಔಷಧಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ಬ್ರಹ್ಮ ಆಯ್ಸ್ ಕೊಟ್ಟಿದ್ರೆ ಇನ್ನೊಂದು ವಾರ ಇರು, ನಾನು ಕೇಸ್ ಓದ್ಕೊಂಡ್ ಬರ್ತೀನಿ, ನನಗೇನು ಫಾರ್ಸೆಪ್ಟು ಸ್ಕಾಲ್ಪೆಲ್ಲು ಹಿಡಿಯೋದು ಗೊತ್ತಿಲ್ಲ, ಸ್ವಲ್ಪ ಟ್ರೈನಿಂಗ್ ತಗೊಂಡ್ ಬರ್ತೀನಿ, ಅಲ್ಲಿವರೆಗೆ ಸ್ಟ್ರೆಚರ್ ಮೇಲೆ ಮಲಗಿರು ಅಂತ ಹೇಳಿದ್ರೆ ಹೇಗಾಗ್ತದೆ? ನೀವು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ವಕಾಲತಕ್ಕೆ ಈ ಸಬ್ಮಿಷನ್ ಮಾಡೋದು ಅಷ್ಟೇ. ಅಪಾಲಜಿ ಅದು ಸಿಕ್ಬಿಡ್ತಿದೆ ನೋಡಿ, ಪುಕ್ಕಟೆ ಶಬ್ದ. ಅದಕ್ಕೇನಾದ್ರು ಜೀವ ಇದ್ದಿದ್ರೆ, ಬಹುಶಃ ಭಾಷೆಗಳಲ್ಲಿ ಪದಗಳಿಗೆ ಜೀವ ಇದ್ದು ತಾವಾಗಿನೇ ಕ್ರಮ ತಗೊಳ್ಳೋದಾಗಿದ್ರೆ millions of cases they would have filed, particularly apology, sorry, mistake, bona fide, unintentional. ಈ ಪದಗಳು ವಕೀಲರ ಮೇಲೆ 10 ಲಕ್ಷ ಕೇಸ್ ಹಾಕಿದ್ರು. ಎಂತೆಂತ ದೊಡ್ಡ ವಕೀಲರಾಗಿದ್ದಾರೆ ಗೊತ್ತೇನ್ರಿ ಈ ಬಾರಲ್ಲಿ, ಇವತ್ತಿಗೂ ಇದ್ದಾರೆ. ಏನ್ ಘನತೆ, ಏನ್ ಗೌರವ, ಕಟ್ಟಿ ಬೆಳೆಸಿ ಕಾಪಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇಂಥದೆಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಏನು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕಾದ್ರೆ ಏನು? ವಾಟ್ ಆರ್ ದ ಡ್ಯೂಟೀಸ್ ಆಫ್ ಅನ್ ಅಪಲೆಂಟ್? ಇಫ್ ದ ಅಪಲೆಂಟ್ ಹಿಮ್ಸೆಲ್ಫ್ ಇಸ್ ದ ಪ್ಲೈಂಟಿಫ್, ವಾಟ್ ಈಸ್ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ ಟು ಡು ಇನ್ ಅಡಿಷನ್ ಟು ಎ ನಾರ್ಮಲ್ ಪ್ಲೈಂಟಿಫ್ ಆರ್ ದ ಅಪಲೆಂಟ್? So what is the consequence of, or what are the obligations of an advocate who files no objection ವಕಾಲತ್? ಏನು ಇಲ್ಲದೆಯೇ ಇಲ್ಲಿ ಬಂದು ಏನೋ ಹೇಳಿ ಏನೋ ಮಾಡಿ ಬೋರ್ಡ್ ಹಾಕಳ್ತೀರಿ ಹೈಕೋರ್ಟ್ ವಕೀಲರು. ನಿಮ್ಮ ವೃತ್ತಿ ಮೇಲಿನ ಗೌರವ, ಅದಕ್ಕಾಗ್ತಕ್ಕಂಥ ಧಕ್ಕೆ ನನಗೆ ನೀಡುವ ವ್ಯಥೆ, ಇಷ್ಟು ಮಾತಾಡ್ಸುತ್ತೆ. Heard the submission of learned counsel for the appellate. As an ultimate opportunity, a week's time is granted to ensure the correct, complete and present address of unsolved respondent number 7 and to take step. Since a memo reporting since a memo showing the legal heirship of existing parties as the legal heirs of a deceased party to the litigation cannot be accepted, since in case if the party to the litigation who is treated as LR raises an objection about his not giving such an instruction to his counsel, would lead to some chaos in the matter. In format ಕೊಟ್ಟಿದ್ದೇನೆ, ಫಾರ್ಮ್ಯಾಟ್ ನೋಡಿ ಹಾಕಿದ್ದು ಗೊತ್ತಿಲ್ಲವರು ಇದನ್ನು ತೋರಿಸ್ತೀನಿ. ಫಸ್ಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಹಾಕಿ ಅದನ್ನು. The memo treating R2 to R7 as the LRs of R1 stands rejected. The appellant is required to make a necessary application with the affidavit in that regard. Yes.
Serial number 26, Shailashri, T.H. Narayana for respondent number 1.
Very important.
The counsel from both sides present at the request of the 11th counsel for the appellant as finally a week's time is granted to do needful in ensuring service of notice to. No, you do needful. Yes.
27, Sridhar NG, VP Shivakumar for respondent number 1.
The respondents number 4 and 7 are the officials of BBMP, and BBMP is made a respondent number. Based on the principles enunciated in Rule 27, read with Rule 29 of Order 5 of CPC, may I persuade your lordships to direct the office to send notice of R4 to 7 to the BBMP who is respondent number 2.
Some submission would be heard here, or some submission can only be read. Your submission is such a submission which the court can read and pass an order.
Please,
It can't hear.
may I request your lordships?
Your submission, you have to put it in writing in a manner known to law.
Well, but Rule 27 and 29, my lord, it contemplates when earlier service
court
has
is
come down,
not-
my lord.
The court is not rejecting your submission. The court is asking to put that in writing and so that we can take the submission on record and pass an order.
Yes, I filed the necessary application.
That is it. As simple as that. Counsel for the appellant is physically present and place a week's time to make necessary application on Article 27 to ensure the service of notice upon unserved respondent number 3 to 7. 4 to 7.
Yes,
3 has been served already.
Yes.
Yeah. Sir.
Please, sir.
Sir. 10 days time has is granted.
may I request your lordship kindly extend it?
Then come in the afternoon. Any request for extension of interim order
Yes.
has to be made along with the first submission, so that the court would decide how lengthy of time be granted. Not after granting a date or adjourning the matter, requesting for extension of interim order.
Henceforth, I should follow.
ಯಾಕೆಂದ್ರೆ ನೀವು ಕೇಳಿದ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು 2 ದಿವಸ ಕೊಡ್ಬೇಕು, 2 ತಿಂಗಳು ಕೊಡ್ಬೇಕು ನೋಡ್ತೇವೆ. ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಇದೆ ಅಂತ ಆದ್ರೆ, ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತಾರೆ ಬೇರೆ ಟೈಮ್ ಕೊಟ್ಟಿರ್ತೇವೆ. ಎಲ್ಲಾಗಿ ಅಡ್ಜರ್ಮೆಂಟ್ ಆದ್ರ ಮೇಲೆ ಕೈಂಡ್ಲಿ IOB ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅನ್ನೋದು ನಾನು ಇವತ್ತಿನವರೆಗೆ 23 ವರ್ಷ ಮಾಡ್ಲಿಲ್ಲ, ಹೇಳ್ತೇನೆ ಬಂದಿದ್ದೇನೆ. ಹಾಗಾಗಿ ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ಬಹಳಷ್ಟು ಮಂದಿ ಟೈಮ್ ಕಳೆದ್ರ ಜೊತೆಗೆ IOB ಆಲ್ಸೋ ಬಿ ಸೈಮಲ್ಟೇನಿಯಸ್ಲಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಂತಾರೆ. ಅವಾಗ ನಾನು ಸೂಕ್ತವಾದ ಟೈಮ್ ಕೊಡ್ತೇನೆ, ಅಲ್ಲಿವರೆಗೆ IO ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೇನೆ.
ಇನ್ಮೇಲೆ ಈ ರೀತಿ ಮಾಡೋದು.
ಎಸ್.
ಇನ್ಮೇಲೆ
ಕೊಡಿ.
ಮಾಡೋದು.
Interim order granted on 23/11/2017 and extended on 24/6/2021 is extended by another 3 weeks from today.
Serial number 28, Vijay AM, PS Ranganathan.
Online. Maybe granted 6 weeks time to find the paper.
Both at present. As requested for the appellant, 3 weeks time is granted by the paper.
Serial number 29, Sachin PS.
Further submission of learned counsel for the appellant on the memo of retirement perused the memo of retirement dated 1/3/2019. A perusal of the said memo, more particularly the narration written beneath the signature of the alleged appellant number 5, does not imply confidence to believe that the other appellants are aware of the retirement of the learned counsel for the appellant and have consented to the same. Hence, a memo of retirement having kept in abeyance, the current counsel for the appellant is granted 2 weeks time to take fresh steps as against the unserved respondents and to cause the issuance of notice of his intended retirement to the appellants in a manner known to law and file acknowledgement for having served the notice of retirement among them within the said time. Yes.
Serial number 30, P Ramesh.
My lords, the respect of respondent number 2, my lords, I make even 2 weeks time, 2 days time to file a substitute application, my lords. Because 3 times I have taken steps. First, my lords, it has been returned with an endorsement. my lords.
Request of the learned counsel
Because
for
Interim
the
order is
appellant,
there,
a
my
week
lord.
time is granted to do needful in the matter. 1 week.
Number 31,
The next date of hearing.
Interim order granted earlier is extended by 10 days from.
Much on.
serial number 31, K Kurubaya, B Janardana for Kevata respondent.
Sorry, Minad, I was unable to serve the copy of this application to the council appearing for the respondent who has filed the proceeding. Also, if preemptive order was made, Minad, I have complied the office objection serving the copy of the appeal memo to the council for the caveat. Then there was a deficiency of rupees, court fee of rupees 89, which that was filed, paid on 9/8, Minad. That is after completion of 15 days. If
Why you could not serve the copy to other side?
I went to the council work, filed a review matter.
Hmm.
And now I came to know only now, Mr. Mahadev Swami is appearing. So I will serve my letter. So this time is granted, I will serve.
Request of the Learned Counsel for the appellant a week's time as finally is granted to comply the office subsequent raised on a 1/80. Yes.
Serial number 32, Sachin BS. Correspondent 2
Respondent.
Both sides, Krishna. As requested for by Learned Counsel for the appellant, for which time is granted to file paper.
Serial number 33, B. Ramana.
It's time for filing application for substitute service of R2 and also paper from book.
Requested for by Learned Counsel for the appellant, to which time is granted. Request steps to one side respondent number 2 and also to file paper.
Yeah.
ಮಧ್ಯಾಹ್ನ ನೆನ್ಪು ಮಾಡಿ. Yes, next.
Serial number
ಸೈನ್ ಆಗದೆ ಹೋದ್ರೆ ಉಂಟು, ಇಲ್ಲದೆ ಹೋದ್ರೆ ಇಲ್ಲ. Yes.
Serial number 34, Ravi Kumar MC.
My lord, I am extremely sorry. There has been a mistake on my part. My lord, because of this COVID problem, my lord, I may be given 6 weeks last chance. I will see that the paper book are furnished. I initially thought that paper book may not.
Of the Learned Counsel for the appellant who is appearing through video conference, for which time is granted. Yes.
Serial number 35, SS Dindra, connected matters. First, RFA 866 of 2018.
Respond number 1 to 5. Connected matter, each time alert should be 10. Connected matter, RFA 1952 of 2018.
Whom you appear for?
For appellation,
Appellant in which matter? There are several appeals.
all of it.
All appeals. Have you filed wakalat in RFA 866 of 2018?
Hearing for respond number 1 to 5. Senior.
What is the name of your senior?
Yes. Here, my lord, senior, send us what.
What is your name? Then why did you move the matter? If you are still to do something in the matter and ensure this service of notice upon the respondent, why did you move the matter?
Take steps. Obviously, steps ತಗೋಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗೋದನ್ನ
ಯಾರು ಹೇಳಿದ್ ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ಮ್ಯಾಟರ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ ನಾನು. I will send along with you the peon. Show him the person. This is the person who told me. My peon will ask him to come over here. He will convey him the direction of the court. ಕಾನೂನು ಅಲ್ಲಿ ಹೇಳ ಕ್ಲರ್ಕಿಗೆ ಗೊತ್ತಿದೆಯಾ, ವಕೀಲರಿಗೆ ಗೊತ್ತಿದೆಯಾ? ಕೇಳಿ 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 ಸಾಕಾಗಿದೆ ವಕೀಲರೇ. ಓ ನಾವು ವಕೀಲರು ಅಂತೀರಿ, ಆಫೀಸರ್ಸ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಅಂತೀರಿ. ಅಲ್ಲಿ ಯಾವನೋ ಕ್ಲರ್ಕ್ ಏನೋ ಸಂಬಂಧ ಇಲ್ಲದ ಏನೋ ಹೇಳ್ತಾನೆ, ಅದನ್ನೇ ನಂಬ್ಕೊಂಡು ಬಂದು ಇಲ್ಲಿ ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಬೇಕು ಅಂತೀರಿ. ಅವನಿಗೆ ಕಾನೂನು ಜ್ಞಾನ ಇಲ್ಲ, ತಿಳುವಳಿಕೆ ಇಲ್ಲ, ತಮಗಿದೆ ತಾನೆ. ಮತ್ತೆ ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಿ? ಅವನು ಯಾರೋ ಕ್ಲರ್ಕ್ ಹೇಳ್ಬಾರ್ದು ಹೇಳ್ದ, ನೀವು ಅದನ್ನೇ ಬಂದು ಕ್ಲರ್ಕಿಂಗ್ ಹೇಳಿದ ಸ್ವಾಮಿ ಅಂದ್ರೆ ಕಾನೂನು ಅವನ್ ಕಲ್ತಿದಾನ ನೀವ? ಹೈಕೋರ್ಟಿನಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತೀರಿ. The land counsel for the appellant Sri L. Narasimha Murthy and the learned counsel for respondent 1 to 25 Sri Sangamesh RBR physically present. This matter was got listed by moving a specific memo to that effect by the learned counsel for the appellant. However, when the matter is taken up, the learned counsel for the appellant prays for a short accommodation to ensure the service of notice upon the unserved proposed respondents number R1, A, D, E, F, and G. In RFEs 1952 of 2011, 1953 of 2011, 1998 of 2017, one 1999 of 2017, it is really surprising that without even knowing the stage of the case, that some of the respondents are still to be served in several of these matters, the appellant, showing some urgency of the alleged possibility of change in the kata before the Tahsildar has got this matter listed, and now he is praying for an adjournment. Thus, he has not properly utilized the precious time of the court in that regard. Hence, granting of any time would be only on the cost. Next one. Perusal of the order should to further go to show that in spite of permitting the amendment of cost title on 4/1/2023 in RFA 1952 of 2011, the appellant has not carried out the permitted amendment. Thus, a week's time is granted to the appellant to take first steps by furnishing the correct, complete, and present address of unserved for the respondent number 1, A, D, E, F, and G in the above mentioned matters, and also to carry out the amendment, however, by imposing a cost of ₹1,000 payable by the appellant to the Legal Services Committee of this court within 3 days from today, and filing, etc., etc. If needful is not done, after paying the cost, registry to list this matter on 21/7. Next one. Since the memo for treaty existing parties as the legal representatives of alleged party to the litigation cannot be accepted, and the same requires application the sworn affidavit. As there is possibility of so format nalide happy. The memo filed to that effect in RFA 1998 of 2017, 1999 of 2017 stands rejected. It would tell why in case if not complies.
Yes, sir. 20 minutes.
Serial number 36. Anil Kumar R.
Appearing for appellant. I have complained the office of the student and paid 1,006.
For the submission of current counsel for the appellant, delayed payment of cost is accepted. Yes, next.
Serial number 37.
First, I filed a memo that the second respondent has died and she has no legal heirs and she was placed ex parte with the court below. I sought for dismissal of the appeal against second respondent. On 7.
When she died,
Yes, 2002.
file a death certificate. For the submission of learned counsel for the appellant on the memo dated 36/2023. The memo is bereft of the particular date of the alleged death of respondent number 2, Srimati Chandrakala. The first appellant claims that said deceased Chandrakala is her stepmother. At the same time, she also says that she has left no legal heirs. The appellant is directed to file death certificate of said respondent number 2, Srimati Chandrakala, before proceeding further in the matter. Each time is granted.
Lords, I have sought for extension of interim order which was there, my lords. By default of mine, I would not seek extension in the last day. I have filed application AL number 8 for extension of interim order.
On the last occasion, it was not extended.
It was not extended.
Then it will.
Then I have filed application, lords, and objections are also filed by the respondent.
On the same day, the IFR, Yadri
8.
Interim order is not extended after 30/05/2023. Rise after that and on every occasion extended. As on the date when the interim order was granted, none of the respondents were alive.
It's only
This is
respondent
total.
number 1, A, who has filed. The objection to this said IA.
I'm appearing for
This said IA will be heard along with after the appellant files the certificate of
On last
Respondent.
occasions, interim order was not extended.
ಹೌದ್ರಿ,
for the reason
ಅದಕ್ಕೆ ಹೀಗ್
Office
ಮಾಡಿದ್ದು.
objection was not complied ಅಂತ. I have complied of all the office objections. Now I am seeking for extension of interim order because the respondents are pressing before the trial court for delivery warrant. That is the reason.
Yes.
This I have.
Death certificate ಹಾಕಿ.
Till number 38, Shirish Krishna, Ashwin
By
Devaraja.
Friday, my lords, I'll do the needful by Friday, my lords.
ನೀವು ಯಾವಾಗ್ಲಾದ್ರೂ ಹಾಕಿ, ನಾಳೆನೇ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ, ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ, ಹಾಕಿ.
Till number 38, Shirish Krishna.
Because there is one officer which is different address to issue notice to respond 1 to 3 minutes. Because my humble submission is that there is an execution petition that is filed by the respondent number 1 to 3 before the trial court.
1 minute, please. Yes, where was the urgency and where was the necessity for you to get the matter listed?
Because the only reason the execution petition 2144 of 2021 is filed by the respondent number 1 to 3 months. Now, on the last occasion, what had happened in the execution petition is that the decree holder, that is the respondent number 1 to 3, had not disclosed before the court of the pendency of the RFA months. And the execution petition is next listed on July 15, 2023, that is the coming Saturday. And the interim order is already there in this RFA minutes, and the interim order is to be extended. That's my only humble submission is.
The execution court was not made known about the interim order passed in this appeal, according to you.
No, ma'am. No, Malaks. We have intimated the executing court. About
You
the
cannot
interim order
intimate, you can only submit to the court.
Please, Malaks, we have
Yes.
submitted before the trial court about the interim order there in place before the passed by this honorable court. So what has happened? The decree holders, they are saying that the interim order will only be in operation only for a period of 6 months.
No. Have you read the Asian refurbishing case
Please,
completely?
No, Malaks,
Does it require any extension in the instant case?
no, Malaks, that is only insofar as trial.
No, you should have convinced the executing court there. Why are you laboring this court?
Please, Malaks, apologies.
Can't do.
Please, Malaks, permitted to serve the copy of this RFA on the
Council,
council appearing before
though you
the.
had an interim order in your favor by moving this matter, you yourself has put yourself into inconvenience.
Oh, my lord, the only reason of this, my lord. And also the summons is returned unserved as the address is not there in the address, but the execution petition is filed by the phone number 123 and the address is same as that of the when it is shown in the RFA. We be permitted to serve the copy and the advocate representing the respondent.
Though it was not required for the appellant to get this matter listed, since the interim order granted in his favor was still in operation. But the counsel for the appellant has moved this matter and got the matter listed on his own. Now the registry has notified that several of the respondents, particularly the respondent, number 1 to 3 and 7 have not been served. Admittedly, after getting the interim order on 19/10/2020, though there was specific order for issuance of notice, the appellant had not evinced interest in ensuring the service of notice upon
My lords, no, I have taken steps.
those
on 22 of-
respondents,
22nd
except
October.
taking step for once. Hence, madam, even today also the appellant has not made any submission about he having taken steps for the unserved above mentioned respondents.
My lords, my submission is.
Hence, the matter stands adjourned.
My lords, interim order may kindly be.
Remember,
We request for extension of interim order
My lords, may kindly pass over. My
for
lords,
above reasons is not accepted.
my lords, I will
Right.
submit it.
Yeah,
The
next.
copy on the.
Right, Ramchandra Rama. 39.
Seven DB.
Number 40, Chalapati R.
Apologies. Today, 2 days of delay in depositing because of the case. But the office objection is blood. There are 3 prayers we have sought in the plaint piece blood. But this prayer B that the judgment, the decree and the judgment and decree passed in OS number 11/5/11 of 1994 is not binding on the plaintiff. That is the prayer we have made. That is the prayer B, please, blood.
1 minute, please. the registry has still say requested you to file any proof of the OS document to verify the value on which you have paid, on which you have computed the court fee at rupees 7,350. It is you who computed that court fee. How you arrived at such valuation, that is what the registry want to know in order to ascertain the jurisdiction here. You have not filed.
But as the evaluation slip, Lord, so far as the prayer B is concerned, Lord, the prayer B is to declare that the judgment and decree passed in OS number 11/511 of 1994, dated so and so, and RFA number so and so is not binding on the plaintiffs in respect of the scheduled property. Is Lord, Lord, the prayer not for cancellation, Lord. However,
Where is that prayer? From what you are reading that prayer be?
plaint, Lord, the plaint, Lord. Prayer B
The
before
decree is
trial
not
court,
drawn.
Lord, decree is drawn.
Have you not filed the certified copy of the decree?
Please, Lord,
You have not filed.
The guidance, yeah, the total value comes around 462.
According to registry, the prayer made is for cancellation. You say that it is not for cancellation. Which is the best document we can see the prayer is the decree.
It is my mistake in the violation slip. The council.
Sir, your mistake. That is what the registry is also telling. That is your mistake. You are required to rectify that mistake. By oral submission won't do.
Not in the under the violation slip, please, not before the trial court advocate was appeared. Inadvertently has valued the is mentioned the provision as 38.
Those mistakes you cannot try to patch up here. You can't do that. That was accepted. The opposite side did not object. The defendant contested the matter, accepting the provision of law shown by you for valuation, the mode of valuation, etc. So, having remained unsuccessful there, now here you cannot come and say that inadvertently your counterpart has done some mistake. No.
Very same court fee I have paid here. Whatever the.
That is second stage. It is not regarding the quantum of court fee. Kindly make a difference between. Then why those all futile exercises? Objection is not that you have paid insufficient court fee. Shall I dismiss for non-compliance of office objection?
Except the valuations.
ಇದೆಲ್ಲದು ಮುಂಚೆನೂ ಇತ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮಗೆ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕಾದ್ರೂ ಈ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು. ಅಲ್ಲಿವರೆಗೆ ಏನು ಹೇಳಲಿಲ್ಲ, ಈಗ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಹೇಳೋದು ನಾಟ್ ಅಕ್ಸೆಪ್ಟಬಲ್ ಅಂತ ನಿಮಗೂ ಗೊತ್ತಿದೆ, ಆದ್ರೂ ಅದನ್ನ ಹೇಳ್ತೀರಿ.
The basis, Lord, provision is mentioned, Lord. There is no specific, specifically it is not asserted before the trial court case, Lord. To arrive under section 38, not prayer, because the prayer B is not binding. 25 rupees is court fee under section 24B, please, Lord. However, they have mentioned as a 30, even otherwise, Lord, if the value is considered as a 38, Lord, then the subject.
I am not here to hear all your submissions, because these submissions you have not made before the registrar judicial. It is for them to hear you first. You had been granted with several sufficient opportunities, including 1,400 rupees cost at a rate of rupees 200 per day. On that day itself, it was specifically made clear to you. ವಕೀಲರೇ ದಿವಸಕ್ಕೆ 200 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ನಿಮ್ಗೆ ಆಗುತ್ತಾ ಇಲ್ವಾ ನೋಡಿ ಹೇಳಿ. ಸುಮ್ಮನೆ ಒಂದು ವಾರ ಬೇಕು ಅಂದ್ರೆ ಕಾಸ್ಟ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ ಮುಂಚೆ ಏನ್ ಪ್ರಯತ್ನ ಮಾಡ್ತೀರೋ ಮಾಡಿ ನೋಡಿ. ಈ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಂಬರ್ 3 ಅನ್ನೋದು ನೀವು ತಿಳಿದಷ್ಟು ಸುಲಭವಾಗಿ ಇಲ್ಲ. ಇದಿಷ್ಟನ್ನೂ ನಿಮಗೆ ಹೇಳಿತ್ತು. ಅಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ರು ನೀವು ಮತ್ತೆ ಟೈಮ್ ತಗೊಂಡು ಆ ಕಾಸ್ಟ್ ಒಪ್ಪಿ ಕಾಸ್ಟ್ ಹಾಕಿಸ್ಕೊಂಡು ಈಗ ಬಂದು ಇನ್ನೊಂದೇನೋ ಸಬ್ಮಿಷನ್ ಅಂತಿದ್ದೀರಿ. ಇದನ್ನ ಯಾವುದೋ ಕಾಲದಲ್ಲಿ ಮಾಡ್ಬೇಕಿತ್ತು ನೀವು.
At this stage, Lord, because it is already valued as per the valuation slip and the very same court fee is paid, Lord, on the basis what they have valued.
Heard the submission of learned counsel for the appellant regarding office objection. Where is the office note? It is pity that the learned counsel for the appellant could not able to make out the difference between the quantum of the court fee and the pecuniary jurisdiction of this court to hear an appeal as to whether it is before a single judge or a division bench. However, the fact remains that the appellant is not ready to comply the office objection. Hence, the appeal stands dismissed for non-compliance of office objection.
Sorry, my lord.
ಇಷ್ಟು ತಾಳ್ಮೆಯಿಂದ ಯಾವ ಕೊಟ್ಟು ನಿಮ್ಮನ್ನ ಕೇಳಲ್ಲ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
41.
Sorry, my lord.
Jason.
I have also placed the guideline. I'm very sorry, Lord. I have also placed the guideline.
ಅದೆಲ್ಲದೂ ನೋಡಿ ಆಗಿದೆ ರೀ. ರಿಜಿಸ್ಟ್ರಿ ಅದ್ರ ಬಗ್ಗೆ ನೋಟ್ ಹಾಕಿದೆ ಮಾಡಿ ಆಗಿದೆ. ಎಸ್.
Number 41. Manoj.
Non-compliance. Yes.
Has sought for partition. Has failed to ascertain to what extent of share the plaintiff is entitled to. The plaintiff, my lord, the second wife and the other plaintiff number 2 to 9 are the children of the second wife. Hence, my lords, for our the memo of valuation, for arriving the valuation of this honorable court, my lords, that for the suit valuation, I have written a submission that
1 minute, please. For the submission of learned counsel for the appellant, there is the written submission submitted with the learned registrar judiciary. The submission of the learned counsel for the appellant is on the line with the written submission submitted by learned registrar judiciary, who in his written submission has stated that the matter lies before the division bench of this court. In view of the above, it will move on. The office objection to be heard on the first day of the hearing of services of notice to all the respondents. The registry is directed to proceed further in the matter. Yes.
Number 42. Pradeep Kumar RH.
27, BB.
Hearing on interlocutory applications, number 43, S. Sridharamurthy, V. Ropesha, correspondent.
For the applying. I'm sorry for not present on the last patient. In this case, the learned counsel of the trial court is a senior counsel. He has accepted, my clients have gone there and met them. Actually, he has accepted to file an affidavit before this honorable court, explaining the entire retirement and filing of the wakalat before the execution court. And I have even spoken to him over the phone also. He's 81 years. He is going to file it by next week. Affidavit ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Yes, what submission you made regarding the not filing acknowledgement for having notified?
ಅಲ್ಲ ಅವರು ಕ್ಲೈಂಟ್ ಪರ್ಸನ್ ಮೀಟ್ ಮಾಡಿ ನಾನು ಅವ್ರಿಗೆ ಫೋನಲ್ಲಿ ಮಾತಾಡಿದ್ದೀನಿ. ಅವ್ರು 81 years, he was not well last 2 months in the problem ಇತ್ತು. ಈಗ ಸರಿ ಹೋಗಿದ್ದಾರೆ. He is coming to the office. He has told that by next week he is going to file the affidavit by explaining his retirement in that case, in the original suit case. ಅದೆಲ್ಲ ಮಾಡ್ತೀನಿ, ನಾನು ಹಾಕ್ತೀನಿ, ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀನಿ ಹೈಕೋರ್ಟ್ಗೆ, ಜೂನಿಯರ್ ಕಳಿಸಿ ಫೈಲ್ ಮಾಡಿಸ್ತೀನಿ by next week. Definitely it is going to be done.
But you had a nearly 1 year time, right?
ಅಲ್ಲ ಅದು ಲಾಸ್ಟ್ ಟೈಮ್
1 year time.
ಅದು ಅವ್ರು ಸಿಕ್ಕಿರ್ಲಿಲ್ಲ ನನಗೆ, ಅದೊಂದು ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು. ಅವರು ಮೀಟ್ ಮಾಡಕ್ ಆಗಿರ್ಲಿಲ್ಲ ಅಷ್ಟೇ, ಇನ್ನೇನು
From both sides.
ರಿಪೋರ್ಟ್ ಹಾಕು.
As requested for learned counsel for the appellant, 3 weeks time has been granted. Yes.
Number 44, S. V. Prakash, A. V. Gangadharappa, correspondent.
We have 1 of 23. I have 1 of 23 minutes. By me, by direction to the executing council proceeding to the matter. But I believe the copy of the hard sheet. The applicant was supposed to deposit the 3 lakh. That has not been done.
1 minute. The counsel from both sides present, heard their submission. The counsel for the appellant submits that the appellant has not made use of the interim order granted in his favor on 16/4/2021 and has pleaded his helplessness to deposit the amount order on 16/4/2021. In the letter, the learned counsel for the respondent also submits that the appellant has not complied the direction dated 16/4/2021 and by not depositing any amount in the bank. In the light of the above, since the appellant has not made use of the interim order granted in his favor and also has not shown any inclination to make use of the same, the order dated 16/4/2021 observing that the appellant shall not be dispossessed, would not inure to the benefit of the appellant. ವಕೀಲ್ರೆ ಆರ್ಡರ್ ಮಾಡೋದ್ ಕೋರ್ಟು ನೀವು ಹೇಳಿದಾಗ ಬರೀಲಿಕ್ಕೆ ಆಗಲ್ಲ, ಬರೆಯುವ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ನಿಮಗೆ ಬೇಕಂದಂಗೆ ಆರ್ಡರ್ ಬರ್ಸ್ಕೊಳ್ಳೋದನ್ನ ಬಿಡಿ. You are on that point only. No necessity for you to file IA for direction. I could have dismissed that IA with cost of 5,000 rupees. I have not done that. If you insist, I will do that. Now I have passed an order. You can reap the benefit of that order. ಮತ್ತೆ ವ್ಯರ್ಥ ಪ್ರಯತ್ನ ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ಮಾಡಬೇಡಿ. ಬರೆಸ್ತೇನೆ ನಾನು ಆರ್ಡರ್ IA ಮೇಲೆ.
Number 45.
ನೀವು ಬೇಕಾಗಿರೋದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದೇನೆ. ಆರ್ಡರ್ ಅವ್ರ ಫೇವರ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೇನೆ. ಇನ್ನೇನ್ ಬೇಕು ನಿಮಗೆ?
I will make use of the order.
Number 45, Jagdish Paliga and
One sentence, the meaning of the same. Meaning of the above order. IA 1/23 does not survive for consideration.
number 45, Jagdish Paliga.
Respondent ಗೆ IA copy ಕೊಟ್ಟಿದ್ದೀರಾ?
Submit ಮಾಡಿದ್ದೀನಿ ಅವ್ರ objection ಆಗ್ತಿಲ್ಲ.
ಹಾಕಿಲ್ಲ. Period ಯಾವುದು? Counsel for the appellant alone present. Then counsel for the respondent not present. Then counsel for the appellant submits that he has furnished the copy. He has served the copy of IA 1/23 to the learned counsel for the respondent. Next line. An endorsement regarding acknowledgement of complete of copy is also shown on the presentation form on IA 1/23. In spite of the same, the respondents have not filed their objection to IA 1/23. Hence, it is taken that the respondents have not filed their objection to IA 1/23. Since the said IA is for production of the additional documents, the said IA be heard along with the main appeal at the appropriate stage. Yes.
Number 46, Lokesh Kumar, KG Sadashivaya for Kevata respondent.
Yes.
First is the purpose of contract. The agreement, they basically given the position for email for appellant.
Now, have filed paper book
I've already filed. There are a special copy on that.
already filed. Probably if pending IS are not present, the matter may be taken up for its final hearing. Learned counsel from both sides present. The applicants in IA 1/17 and 1/18 submit that since the matter is ripened for final hearing, they would not press on those two IAs. Hence, IA 1/17 and 1/18 are disposed of as not pressed. Registry to verify, and if the matter is otherwise ripened for final, if the matter is already ripened for final hearing, list this matter for final hearing in the week after next.
Number 47, Pancham Harding, K Subramania for impleading respondent.
Learned counsel Subramanian. Copy is not served on me, my lords. My lords, today I have also filed an application under order 1.
Who have filed?
I have filed today.
You have filed.
Please, my lords.
Learned counsel for the appellant submits that copy of IA 1/23 has not been furnished to him. He further submits that today he has filed an IA and R1 Rule 10. The registry to verify the same and do legal. Yes.
Seal number 48, just Sebastian.
None of parents the matter.
Seal number 49, Basuraj DP. Seal number 50, Theo Herade.
What a suit was for?
For parties.
No, PCR.
51, Munraju S. Timegoda L. For Kyoto respondent.
The application file for the recall of the order dated as 7/6/2022, which was sent to RPT to the opponent counsel.
Yes, please.
Lord, the application for recall of the order dated as 7/6/2023 is filed. Lord, in fact, we have filed the posting memo, but I requested my colleague to appear on that day on 7/6, but unfortunately he was absent before the son of report. And in view of his absence and the non-compliance of the after objections with regard to the payment of the DCF, the case has been dismissed. Therefore, the application is for the recall of the order.
Are you ready to comply the office subsection 4(3)
Lord,
right now?
Lord, I have already complied. Lord, the DCF has been remitted on the 8/6 itself. The next immediately and the next day of dismissal order, the DCF has been remitted to the office.
In a dismissed matter, how could you remit the DCF and how could the registry accept the DCF?
In the counter writers, we are not noticed about the dismissal order. In the next day, immediately.
No, how can you plead that you did not notice the order?
Next day,
With all courage, you are making that submission. Being an advocate, are you not supposed to know whether the appeal is pending or not?
it was dismissed on 7/6.
Then, how did you pay the process the DCF there? ಎಷ್ಟು ಬಹಳ ಕ್ಯಾಶುವಲ್ ಆಗಿ ಹೇಳ್ತೀರಲ್ರಿ ವಕೀಲರು ತಾವು ಕೇಸ್ ಇದೆಯೋ ಇಲ್ವೋ ಕೇಸ್ ಬದುಕಿದೆಯೋ ಸತ್ತಿದೆಯೋ ನೋಡದಂಗೆ ಹೋಗಿ ಮಾಡಿ ಬಿಡದೆ ಅದನ್ನ ಮತ್ತೆ ಅಷ್ಟೇ ಕೂಲ್ ಆಗಿ ಹೇಳ್ತೀರಿ ಯಾವುದೇ ಸಂಕೋಚ ಇಲ್ಲ ಹಿಂಜರಿತ ಇಲ್ಲ ಎಲ್ಲಿಗೆ ಬಂದಿದೆ ನೋಡಿ ಪರಿಸ್ಥಿತಿ ವಕೀಲ್ಗಿರಿದು ಮುಂಚೆ ಸ್ಟಾಪಲ್ ಸರಿ ಮಾಡಲಿಲ್ಲ ಸ್ಟಾಪಲ್ ಕಾಲ ಅಲ್ಲ ಹೊಲಿಗೆ ಸರಿ ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಕೀಲರಿಗೆ ಸಂಕೋಚ ಆಗೋದು ಕ್ಲರ್ಕಿಗೆ ಆಫೀಸಲ್ಲಿ ಕ್ಲಾಸ್ ತಗೊಳ್ಳೋರು ಏನೇ ನೀನು ಹೊಲಿಗೆ ಸರಿ ಹಾಕಿರ್ಲಿಲ್ಲ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟಿಗೆ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಯ್ತು ಪೇಜ್ ಟರ್ನ್ ಮಾಡೋದ್ರಲ್ಲಿ ಹಂಗ ಹಾಕೋದು ನೀನು ಆಫೀಸ್ ಮರ್ಯಾದೆ ಕಳೀತಿ ಅಂತ ಈಗ ಎಲ್ಲಿ ಬಂದಿದೆ ನೋಡಿ ಸಬ್ಮಿಷನ್ ಕೇಸ್ ಇದೆಯೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ ಐ ಡಿಡ್ ನಾಟ್ ನೋ ದಟ್ ದ ಕೇಸ್ ಅಪೀಲ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ I went and filed the DCF there. ದುರಂತ ವಕೀಲ ಏನ್ ಸಾರಿರಿ ಸ್ವಲ್ಪ ಸಂಕೋಚ ಹಿಂಜರಿತ ಅನ್ನೋದು ಇರ್ಬೇಕಲ್ವೇ ಬೇಕಾದ್ ಬಿಡಿ ಅವನು ಬಿಟ್ಬಿಡದೆ The direct counsel for the appellant submits that the deficit court fee of rupees 40,170 has been paid by the appellant to the registry on 8/6/2023, which date was admittedly the next day after the dismissal of this appeal. The direct counsel for the appellant could not convince the court as to how come he has paid the deficit court fee in a dismissed matter. It is also not known how come the registry has accepted deficit court fee when there was no appeal pending as on the date of the alleged payment of the alleged deficit court fee. Registry to verify and make its submission. Reach the matter on 18/7.
Admission matter still number 52. M. Vinay Kirti, B. K. Manjunath for respondent.
ಅಲ್ರಿ ಲೋಕ ಅದಾಲತ್ನಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂದ್ರೆ ಮತ್ತೆ ಇಲ್ಲಿ ಯಾಕೆ ಬರುತ್ತೆ ಇದು FTP ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಇದನ್ನ ನಾಟ್ ಪರ್ಸೆಂಟ್ ಒಂದು ಮೆಮೊ ಹಾಕಿ ತೆಗಿರಿ ಪಾರ್ಟಿ ಯಾಕೆ ಬೇಕು ವಕೀಲರು ಸೈನ್ ಮಾಡಿದ್ರೆ ಸಾಕಾಗ್ತದೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ ಒಂದು ಮೆಮೊ ಹಾಕಿ ಮೆಮೋದಲ್ಲಿ ಯಾರು ಸೈನ್ ಮಾಡ್ತೀರಿ ಅದರಲ್ಲಿ ಅವ್ರದ್ದು ವಕಾಲತ್ತಲ್ಲಿ ಸೈನ್ ಇರಬೇಕು. At the request of the learned counsel for the appellant who submits that since the parties have settled the matter, should files a memo not present the appeal, the matter stands passed over.
Bill number 54. N. Jayaprakash Rao.
Appearance, the matter could not be proceeded with.
55, Vasantappa.
Was filed by client. After the client was dismissed. On that, is it bought by limitation?
Only on the ground of limitation.
Good fee is not paid on the.
Hmm.
The documents produced by the client is not substantiate that name of the grandfather is not shown.
So there are several reasons for dismissal.
Documents is produced, my lord, but trial court was error, I think. It's a document, my lord, it stands in the name of her grandfather, one Abbayarati. Sale deed was produced.
Notice TCR.
Number 56. Shivapatrappa Emanappa.
For declaration and injunction against the defendants, declare that the plaintiffs were the archakas of the scheduled temple. The suit was decreed. I was one of the defendant impleaded in that suit. I am before my lords questioning the low court's order, my lord. Lord, one of the primary ground that I had taken challenging the plaint was that it is not maintainable since the temple belongs to the Mujarai department, and as such, as per section 68 of the Karnataka Hindu Religious Charitable and Endowments Act, the jurisdiction of the civil court is barred. The lower court has
Notice TCR. Steps down.
Number 57. V. Ramaswamy Iyengar.
The point as filed for suit for permanent injunction. And apparent defendant Slumboard has produced several documents to establish its possession and rights over the property. In spite of the same, the court below has, without considering the documents, has fallen error and granted decreed the suit file. Reviewed by the decree and before this court. Initially, that the survey number 109 is a government land consisting of more than 200 acres. Without producing the original, that is the mother deed of the document claimed by the plaintiff, the court has fallen into error, saying that already an injunction is there in respect of the other sites on the same survey number. It has decreed the suit, which is not correct. Cannot be given sufficient opportunity to prove my case number. That also I am before this.
PCR paper book 6 weeks.
Number 58, Mithun.
Not for stay on.
58, Mithun GA. Gangadhar SI Thought.
I'm not in a position to file application, not filing the.
Because of either of the microphones.
Please. Not in a position, your lordship may take it as not filed. Your lordship was granted me, granted me an opportunity to file the objection. I have written a letter, but I could not get it. I am not filing it. Your lordship may hear for the admission, I have no objection. And that's it. Well, the airport said that he is not in a position. He is not in possession of the property. Secondly, the suit is not maintained. The ground that the declaration has not fought for in view of the judgment, the suit has to be. That's the gist of the judgment of the Grand Court. Not in possession, it is not true. It is not maintained with the judgment of the court. Right. Speak.
Both of them maintain status. Checked. Learned counsel from both sides percent. Counsel for the respondents have not filed their objection to IA 1/23, but of granting sufficient time. Next line. Heard both sides on IA 1/23 filed by the appellant and other pertinent rule 1 and 2. Read with section 151 CPC. Next line. The applicant in the IA is the plaintiff in the trial court. Being an unsuccessful plaintiff in a suit for permanent injunction, he has come up through this appeal. The plaintiff claims that he is in possession of the suit-solely property as a donee of the same by his mother, Srimati Sithamma. He has also further contended that during the disposal of the original suit, he was enjoying the privilege of interim order in his favor. Next line. The suit of the plaintiff came to be dismissed by the trial court, stating, observing that a suit for bare injunction is not maintainable when there is serious dispute with respect to the title over the suit-solely property. In the light of the above, and more particularly since the respondent, despite having sufficient opportunity, has not filed their objection to the end of consideration, I am of the view that both side parties be directed to maintain status quo as on date to the next date of hearing. Ordering accordingly, IA 1/23 stands partly allowed and stands partly allowed. Call for trial court reports. Yes.
Serial number 59, Sachin BS.
For appellant matters, the appellant has filed a suit for damages and maybe matters. It was
Damages for what?
information matters.
Oh.
That's the
ಎಷ್ಟು ಕೇಳಿದ್ರಿ damages?
that's it.
Why you lost your suit? Why you lost your suit?
That's we have failed to prove the involvement of the defendant in the suit. My lords. Page number 57, paragraph number 3.
And notice. Paper book 6 weeks, TCR.
Serial number 60, Hegde Shripad Gangadhar.
Property that was acquired by the appellate authority for valuation of calculation. Slide referring to as one of 5(6). In survey number 81 or 4 of renewed regulation. Survey number was totally measuring 1 acre 9 hectares, out of which 1 acre was acquired in the thereafter, not the according to the she is purchased, he has purchased it in she has purchased it in
The GPSA. Sale through GPA holder.
purchased in 1992, she says.
Hmm.
The acquisition took place in 2002 and final notification 2004. This portion of the property which she is claiming is the unauthorized occupation and unauthorized possession has been order has been passed which has been produced before the court, and having observed that the trial court has granted the injunction. Decree of injunction. Exhibit P5.
75. Now P5, sir, P5.
An acquired property, in fact, restriction to obtain this soon. Title as well as intention. With respect to the acquired properties when the property that
Hmm.
that's the input jurisdiction clause that is.
Same order. Admit. Notice, paper book, please.
So the interim order, there is a status order for the transfer from the application filed by the other side which is contested. Similar order could be not extended to this itself.
Burley, you have taken sufficient time. More than 1 year is lapsed.
Syllabus 61.
Notice hogi bari.
61, Shankar Ji, Gopal Singh for Canada respond to.
Possession. One and two and three filed objections to the main appeal, not the but they have adopted a memo adopting the position to main to the email activity.
Counsel for the
Property.
appellant alone present, counsel for the K-Wait respondent not present. List the matter on 13. 7.
The R1 is not so, the notice. R1 is R2 and 3 file K-Wait, they are representing.
Counsel for the appellant alone present, counsel for K-Wait not present.
R1 has filed written statement before trial court, but he has not.
Emergent notice to the respondent number 1. Plan to pay the respondent number 1 both on the main appeal and on pending AEs. Appellant to pay the necessary process and furnish copies in the registry if not already done within a day from today. This is the matter on 2/8.
I have sought for interim order not to end.
ಹೌದ್ರಿ ಅದಕ್ಕೆ ನಾನು ಹೊರಗದು ಕೆ ವೇಟಾರ್ಗೆ ಅಂತ ಹೇಳಿ ನಾನು ಹೇಳಿದ್ರೆ ನೀವು ನೋಟಿಸ್ ಇಸ್ ನಾಟ್ ಆರ್ಡರ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಅಂದ್ರಿ ನಾನೀಗ ಚೇಂಜ್ ಮಾಡಿದ್ದೇನೆ. ನಾನು ನಿಮಗೆ ಫೇವರ್ ಆಗಿ ಆರ್ಡರ್ ಮಾಡ್ತಾ ಇದ್ದೆ, ನೀವು ಇಂಟರ್ಫಿಯರ್ ಆಗಿ ಅದನ್ನ ಬದಲಾಯಿಸಿದ್ದೀರಿ, ಮತ್ತೆ ಬದಲಾವಣೆ ಸಾಧ್ಯ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್
62, Hanif MH.
Payment
1 minute please. Have they filed execution? They have filed. EP number?
21 of 2020. 21 of 2020.
Pass over the. For the submission of 11 council for the following. One got 23, filed under Article 41 Rule 5 for a such a note to the CPC. There is the ID. The affidavit accompanying this. Defendants who are the judgment records in the trial court and supplying a decree of declaration. A possession in power of the plaintiff have come up in this appeal. You are the purchaser of the property. Appellants claim that they were the purchaser of the property. However, their sale deed was held to be not binding on the plaintiff. The appellants are directed in the impugned judgment and decree to vacate the social property and hand over the vacant possession of the social property to the plaintiff within 30 days. In the light of the above, I am of the view that since impugned judgment is executable and according to the counsel for the appellant, the decree holders of the respondents have already filed an execution petition. There is a need for issuing the interim prayer, though limited by time. Accordingly, IA 1/23 stands allowed and operation the execution of the operation execution that the IA allowed in part. There shall be a stay of the operation of the judgment dated 13/2/2023 and the decree dated 23/2023, passed by so and so for a period of 4 weeks from today. Issue emergent notice to the respondents, TCR. Yes. ಸಾಯಂಕಾಲ ಕೊಡ್ತಿದ್ದೆ ಮಧ್ಯಾಹ್ನ ನೀವು ನಿಮ್ಮ ಫೋನು ಎರಡೂ ಜಾಸ್ತಿ ಗಲಾಟೆ ಮಾಡಿ. ಹೌದ್ರಿ, ನಿಮ್ಮ ವೈಟ್ ನಾಟ್ ಫೀಲಿಂಗ್ ವೆಲ್ ಅಂದ್ರೆ ನೀವು ಅಷ್ಟು ಗಟ್ಟಿ ಮಾತಾಡೋದೆ. ಯು ಮೇ ಆಲ್ಸೋ ನಾಟ್ ಫೀಲ್ ವೆಲ್ ಬೈ exhaustion if it speaks so loudly.
Yes, ಸಿಗ್ತಾ ಇಲ್ಲ ಹಾಗಾಗಿ my colleagues.
Yes.
We need to withdraw that. That is already settled before the FTP. We already sent it before Lok Adalat, sent it and
ಬೆಳಗ್ಗೆ ನಿಮ್ಮ ಕಲಿಗೆ ಬಂದಿದ್ರು ಬೇಕಿತ್ತು, ಅದು ನೀವು ಕಲಿಗೆ ಹೇಳಿ ಕಳಿಸ್ಲಿಲ್ಲ. ಪೇಪರು ನಾವೇ ಕೊಟ್ಟಿದ್ದೇವೆ, 10 ರೂಪಾಯಿ ಪೇಪರ್ ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಬನ್ನಿ, ನಿಮ್ ಕಲಿಗೆ ಮಧ್ಯಾಹ್ನ ಇರ್ಲಿಕ್ಕೆ ಹೇಳಿ, ಜೂನಿಯರ್ಗೆ ಕೆಲಸನ ಕರೆಕ್ಟ್ ಆಗಿ ಕಲಿಸಿ ಕೊಡಿ.
So matters, still number 5, Sri Vasant Kumar.
Yes.
Madam, I have inserted only page, note. All I've done it, my lordship, I have retained my original appeal behind the behind the appeal, my lordship. And I have not done it intentionally. It's a bona fide thing, my lordship. Humble submission. I will consider, my lordship.
And again in the afternoon, heard the submission of current conflict for the opponent who submits that. That was unintentional and bona fide. Not known how come the learned counsel or suspects any bona fide in his alleged act. But only the court noticed, but the court only noticed that the learned counsel ought not to have substituted the fresh memorandum of appeal in the place of the original one without the leave of the court. In the light of the above, since the learned counsel for the appellant submits that the original memorandum of appeal is also placed with the main appeal at the end portion of it, in the main appeal, at the last pages, the registry to secure the same and ensure the carrying out the ensure the compliance of office subjection in the original memorandum of appeal, and then to proceed. A week's time is granted to do needful, including compliance of office subjection if any still due for its compliance. Yes.
Still number 8, Sri Revan Abdullah.
You filed in the registry. Have you filed such an application in the registry, or are you filing it now?
I have already filed in the government.
Already
Copy
filed.
of the same is showing.
Called again in the afternoon, learned counsel for the appellant submits that he has filed an application seeking substituted service of notice upon unserved respondents in the registry. This morning, registry to verify. I put up the application is filed. Yes.
Case number 50. Sri Vijay Kumar K.
Pay for a week's time to do the. I will ascertain the correct address and I will furnish this.
As requested for by Learned Counsel for the appellant. Which time is granted to ascertain the complete and present address of unserved respondent and to take step.
Case number 33. Sri Raman.
This time for filing the application for a substituted service. What is it? Also paper. For R2 only. For R2 only. For 2 weeks time for filing application for substitute service and paper.
Yes. That has been already granted.
Yes.
It's not, no. Yes. ಬೆಳಗ್ಗೆನೂ ಇದನ್ನೇ ಮಾಡಿದ್ರಿ ನೀವು ಈಗಲೂ ಕೇಳಿದ್ರೆ ಎರಡು ಸರ್ತಿನೂ ಬೇರೆದನ್ನೇ ಹೇಳ್ತೀರಿ.
Number 52.
Yes.
Sri M. Vinay Kirti. Number 52.
Called again in the afternoon. None appear in this matter, either physically or through video conference. When the matter was passed over at the specific request of the Learned Counsel for the appellant, who submitted that the parties have settled that assets. Should not, the assets should file a memo, not rescind the appeal. However, when the matter is called again, as desired, counsel for the appellant has remained absent. The appeal is of the year 2017. Under the appellant is not evincing interest to proceed further in the matter. Hence, the appeal stands dismissed for prosecution.
Question matter, Sri number 63. Sri Suraj Babu BN. Sri VB Ravishankar for Kevatar R1 R2.
The appellant before your lordships is the defendant in the
Do you have any objection to be filed by you?
Objection to the. Thank you, Lord.
Since how long he is your tenant? Since how long he is your tenant?
The last 10 years.
10 years. Whether your client expects some more time to vacate or he has got a strong grounds to oppose the eviction?
There was no list, Lord. I filed a suit on, after the death of the mother, I filed a suit for partition on behalf of the 3 daughters, Lord, in the year 2018. That vengeance they have taken and filed only by the 2 of the co-owners, the suit for ejectment, Lord. The suit for ejectment.
What is the relationship between partition suit and ejectment?
Lord, what my respectful submission is, Lord, there are 5 legal heirs of the personal owner, Lord, Mr. Srikantappa, Lord. After his death, the property was succeeded by his wife and the children's blood, Rajmani and others, blood. I was a tenant inducted under Srimati Rajmani, blood. I was paying rents as long as she was alive, blood. Then I filed a suit, after the death, I filed a suit for partition on behalf of the 3 of the daughters, blood, in the year 2018. So all the co-owners are not included in this suit, blood. The co-owners issues a notice, that is the daughters issues a notice to me, claiming that 60% of the rent has to be paid to me. Paid to them. That is, they being the 3 daughters. They filed a suit for ejectment. I have disputed the landlord-tenant relationship on the ground that it was originally all the 5 legal heirs have succeeded in the property. Then they claim that they have succeeded to the property on the basis of a will dated 11/5/1994. That will is not exhibited anywhere in the suit trial. The primary issue was framed. The issue number 1 was whether they prove that they are the landlords and have the tenant relationship. That issue, like placing the reliance on the judgment of the apex court in the case of Indian Umbrella Manufacturing Company, the trial court supports that issue, because the 2 co-owners. What that judgment says is, unless it is the other co-owners are not disputed. Here, the co-owners themselves issues a notice to me, Exhibit D1, claiming that we have entitled for 60% share as such. So the main ground which I am respectfully submitting,
How long you expect to vacate?
now I am 60 years old. I am an advocate by profession. Another 3 years time is granted. I wanted to wind up my office itself. I want to quit the profession. That is the instruction what I have received from the advocate. He is also not well. After this Corona time, because he was only a documentation advocate after the Corona, he suffered a lot of problems. As such, if 3 years time is granted, he will vacate and he will.
Can you grant him 3 years time as paid?
3 years. At least 1 year, Lord, I would be very fair enough to see it. 1 year, Lord, definitely. If we had not touched him, that is 1 year. That would be rather fair to accommodate him as an advocate.
There are about 8 shops, Lord. It's not that they require that shop. There are 8 shops. Because I tried to assist the sisters, it is the vengeance which is against me.
Sorry, that.
I filed for partition 2018. That is only the vengeance. Other than that.
Can you talk to your client, asking him, say, whether he can consider their counter proposal of 1 year and make his submission?
At least only 2 years quarter I will instruct him. Papa, no office wind up Martin. 60 years.
3 months, 1 year. I want a shop for my daughters there. With a chartered accountant. In fact, she wants to open her own.
ಬೇಕಾದಷ್ಟು ಇರ್ತದ್ರಿ ಅವರಿಗೆ ಬೇರೆದಿಲ್ಲದು. ಚಾರ್ಟರ್ಡ್ ಅಕೌಂಟ್ಗಳು ಅವ್ರದ್ದೇ ಶಾಪ್ಗಳಲ್ಲಿ ಇಟ್ಕೊಳ್ಳಲ್ಲ ಅವರು. ಇದರಿಂದ ಬಾಡಿಗೆ ಬರ್ತದೆ, ಇನ್ನೊಂದು ಬೇರೆ ಕಡೆಗೆ ಅವ್ರು ನೋಡ್ಕೊಳ್ತಾರೆ. ಕೇಳಿ ನೋಡಿ. His request also appears to be genuine. So he has come down to 2 years without any legal haggles.
1 year, 3 months, 1 year, 4 months, I would be rather.
ಕೇಳಿ ನೋಡಿ.
Because the daughter has become a chartered accountant now. Only we have daughters. I don't have any sons. The other has 1 son there. Please, that's only that ground. My daughter wants. I am accommodating them. She wants to open an office now.
That is only the problem, because I have personally seen him. He has
Chartered
suffered a lot from the
accountant,
Corona time. He has suffered a lot because of he was a documentation advocate, and he could not because of the Corona time. He suffered a lot. That is why my only respectful submission. Now he has established office there.
Maybe
2 years,
1 year, 6 months.
2 years.
Come down. 1 year, 6
I
months.
did not bargain before your lordship's blood. I straight away said 2 years blood. That is the maximum blood. In 6 months, I can say now I have 60. Another 2-3 years, I will wind up my practice. That is the instruction what I have received from the client blood.
ಆಮೇಲೆ ಮತ್ತೆ ಈಗ 1.5 year ಅಂತ ಕೊಟ್ಟರು ಮೇಲೂ ನೀವು 1.5 year ಎಂಡಿಗೆ ಬಂದು ಇನ್ನೇನು ರೀಸನ್ ಕೊಟ್ಟು
ಇಲ್ಲ 2 years ಗೆ ನಾನು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ.
Let them be 1 year, 6 months, then you see lots there.
ಅಲ್ಲ ನಾನು ಒಂದ್ಸಲ ಕಮಿಟ್ಮೆಂಟ್ ಕೊಟ್ಟಮೇಲೆ 2 years on the bar we cannot also say the advocate that on the bar you can make another application.
ನೋಡಿ as a
on the bar he has to
responsible advocate
make
his client
Lords, I have come
undertakes to vacate voluntarily
Lords,
at the end of 2 years.
I have come down to an extent of 1 year, 6 months, Lords. I have been very fair without even consulting my client. That's whether I would have been.
Maybe say,
Commercial
the
premises.
point is, this is an established office since a long time. And he is planning to wind up his avocation and put an happy ending for his profession. A peaceful ending, not happy ending, a peaceful ending for his profession. Whereas your daughters are yet to commence.
Yes, he's already working. She wants to become an independent. Lords, he started independent job. This is very difficult. He has to get some.
office there something.
But ಕೇಳಿ ನೋಡಿ, you consult. 3 years ಹೇಳಿದ್ರು, ಈಗ 2 years ಅವರು ಬಂದಿದ್ದಾರೆ. ನಿಮ್ಗೇನಾದ್ರೂ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ನಾವು ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಆಮೇಲೆ ಅದ್ರ ಮೇಲೆ ಏನು ಅಪೀಲ್ ಏನು ಇರಲ್ಲ.
I will give all those undertakings.
ಹಾಗಾಗಿ
I will consult him and keep him present to the court. Please make them keep present, but he may not.
Without that
ಅವರಿಗೆ ಕೆಲವುದೆಲ್ಲ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ವಿಚ್ ಮೇ ಫ್ಲೋ ಐದರ್ ಸೈಡ್ ಅನ್ನೋದು ಹೆಚ್ಚು ಗೊತ್ತಿರಲ್ಲ ಅವರಿಗೆ. ಹಾಗಾಗಿ ಬೇಡ ಇಂಥದ್ರಲ್ಲಿ ನೋಡಿ, ಮನಿ ರಿಕವರಿ, ಈ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಟೆನೆನ್ಸ್ ರಿಲೇಶನ್ಶಿಪ್, ಚೆಕ್ ಬೌನ್ಸಿಂಗು, ಇಂಥದ್ದೆಲ್ಲದನ್ನು ನಾವು ಸ್ವಲ್ಪ ಕೊಡೋದು ತಗೊಳ್ಳೋದು ಮಾಡಿದಾಗ ಬಾಂಧವ್ಯ ಚೆನ್ನಾಗಿರ್ತದೆ, ಮುಗಿದೋಗ್ತದೆ. ಇಲ್ಲೇ ಅದೃಷ್ಟ ಕೆಟ್ಟಾಗ ಏನೇನೋ ಎಡವಟ್ಟಾಗಿ ಬಿಡ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ಬೇಡದೇ ಇರೋರಿಗೆ ಹೋಳಿಗೆ ಊಟ ಬೇಕಾದವ್ರಿಗೆ
When the
ಉಪವಾಸ.
matter was pending before the court below, I offered him take 3 years time and can quit. Even the court below has asked him take time and vacate. He did not agree at that point of time. This would not have come before your lords. The time was proposed there. 5 years there was.
In the beginning, in the first instance, generally nobody will accede to those good or genuine advisors. It is only after they suffer a decree at the initial stage they do it. And you must be happy that say your case came to an end within 3 years after filing.
The lords.
It did not take decades together. Generally, these kind of litigation should take 7-8 years.
Your lords.
But you are lucky, say within 3 years it has happened.
When a sword is put on their head, only they come to know what will the consequences of it now. Your lords may have it next Monday. Your lords may have it at consultation.
New nodi. The other side also was quite considerable to.
I made a fair submission, Lord, because considering his request that he suffered in the corona as well as he wants to close that because his son is final year MBA. So he, as good as he could get a job by next, he wants to leave this profession and look out for elsewhere. Because he has not.
ಆದ್ರೂ ಒಂದು ಮಾತು ಕೇಳಿ ನೋಡೋಣ. Hardly 2-3 months this side that side ಅಂತಾದ್ರೆ ಇಬ್ಬರಿಗೂ ಟಿಲ್ ಮಂಡೇ ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿಲ್ಲ, ಹಾಕಿದ್ರು ಕೂಡ ಅದ್ರಲ್ಲಿ ಮುಂದುವರಿಯಲ್ಲ. ನೀವು ಕನ್ಸಲ್ಟ್ ಮಾಡಿ.
I'll keep you present.
Yes, both of you. The counsel from both sides present. After some deliberation, they submit that they would consult their parties about possibility of settlement and make their submission. The matter. It's the matter on 17/7 aspect.
Further arguments, serial number 64, Sri Jeevan Kumar BS, B Sharat Kumar. with connected methods.
Yes, please.
Last occasion was three facts is stated. I take my notes, kind consideration, the evidence part. The cross examination has been conducted. Actually,
The vendors to the plaintiff in all the suits was the same person or different person? Vendor was the same person. Ramakrishnappa.
all the four members. Ramashnappa,
Lakshmi Hanumantrayappa, Kempanna,
and Sachidananda.
Sachidananda.
Recitals I'll take it to the sale deeds also, whether they have shown him as a power of attorney holder, whether he has executed as a vendor. Reiteration of the claim.
For all the 5 plaintiff, GPA holder Sachananda was there.
He forms a layout. The surveyor.
Yes.
Along with the overseas sensitive property, he has also joined as a vendor. This he was an interest.
Yes, please.
May I read the cross examination of PW1? The documents which have been marked. Certified copy of the register dated 1158. Certified copy of the register dated 2004. Encumbrance certificate at exhibit P3, tax demand registered, extract marked as exhibit P4 and 5. Taxpayer receipts marked as exhibit P6 to 8. The original sale deed is again marked as exhibit P9, and taxpayer receipts are marked as exhibit P10.
Yes.
May I read the cross examination?
Please.
I cannot say towards which direction the suit property is situated in survey number 45 bar. The 45/3 is a larger extent of 4 acres 16, out of which dependent only owns 1 acre 18. And even till today, it is a vacant site and no construction has been put up, to my information, in the entire extent of 4 acres. Learned friend in the last occasion said that there are houses which are being constructed. To my instructions, I have a photograph to show that there is no construction in the entire extent of 4 acres. The total extent of survey number 45/3 is 4 acres 15 meters. It is true that my vendor or minus at the time of executing exhibit P1. Survey number 45/3 is also mentioned in it. I have not seen any other document except the sale deed at the time of purchase. It is false to suggest that Tamanappa had got 5 sons and they have got partitioned the property on 25/3/1982. They have produced the partition deed and converted the land from agricultural to non-agricultural. It is false to suggest that such survey number, in view of the partition, the defendant has got 1 acre 18 guntas of the land. I do not know the contents of the written statement. It is false to suggest that suit property comes within said 1 acre 18 guntas of the land allotted of the defendant. My vendor Sachidananda has got GPA from other 3 owners. There are totally 4 vendors. But however, the entire proceedings GPA has not been produced. In the plaint, along with the plaint or in the evidence, no GPA has been produced. Though they say that I have produced the GPA, documents marked substantiate that GPA was not produced. It is false to suggest that exhibit P2 and P9, there is no mention regarding the GPA. I have seen the GPA. It is false to suggest that Ramakrishnappa, Lakshmi Hanumantrayappa, Kempana have not executed GPA in favor of Sachinananda. I do not know whether they are brothers of the defendant. It is false to suggest that my vendor are not the owners of the suit property at the time of execution of sale deed exhibit P2 and P9. It is false to suggest that as per the orders passed by the Assistant Commissioner, the defendant name is entered in respect to survey number 45/3 to an extent of 1 acre 18 guntas. It is false to suggest the date of execution of sale deed, my vendors were not in possession of the suit property. Sachidananda has formed the layout in survey number 45/3. He has formed 64 sites. I have produced the conversion order and plan in this regard. Thus, no conversion order nor the plan has been produced by the plaintiff. It is false to suggest the suit property is not within 1 acre 18 guntas of land allotted to the defendant. In order to show that I am it is subsequent cross-examination. In order to show that I am in possession of suit.
1 minute.
With regard to formation of 64 sites.
Cross-examination previously read, it is false to suggest that suit property comes within the said 1 acre 18 guntas of the
Not
land allotted to defendant.
Not within 1 acre 18.
It is false to suggest that suit property comes within the said 1 acre 18 guntas of the land allotted to defendant.
Not,
Last sentence,
not of the suit property.
it is
not
false to
within-
suggest that the suit property is not within
Not
1
within
acre
1
18 guntas of land allotted to defendant. Are they not contradictory to each other?
Must they claim that this scheduled property would come within 1 acre 18 guntas, but they have not produced any document to substantiate that this property comes within 1 acre 18 guntas, because in the first instance, my lords, they say that they doesn't know where this property is being situated within 4 acres 16 guntas.
No, out of 4 acre 16 guntas, how much of the property that has gone to the defendant?
3 acres. 2 acres 38 guntas. Out of 4 acres 16 guntas, if this defendant has acquired 1 acre 18 guntas, the remaining would be 2 acres 38 guntas.
That is what, say your contention is that 1 acre 18 guntas of property has fallen to your share.
My share.
And it is in your share, the property which has fallen in your share, these sides are alleged to have been carved. That is your contention. So in that regard, if that were to be your contention, whether these two statements, what you read now, in the middle of the cross-examination of PW1 and at the last sentence of cross-examination of PW1, are they not contradictory to each other?
That is the reason why I said in the initial stage itself, identity of the property is itself in the question. Because there is no survey being conducted in respect of these sites or in respect of the entire property as to where this property is situated. When an identity of this property is situated, they should have approached the civil court for a suit of declaration, and they could have done the survey being conducted to identify their site, where it has been situated, whether it is situated in 1 acre 18 guntas or within the extent of 2 acres 38 guntas, 36 guntas belonging to the vendors.
Assuming that there is some confusion regarding the identity of the property, whether the suit for declaration is the remedy?
Yes, that is what the apex court has said. When there's a cloud with regard to title and
Cloud regard to title,
and
Mr. Counsel, is there no ocean difference between cloud regarding title and identity of the property?
and with regard to identity of title, identity with regard to dispute with regard to identity of the property, the suit which they ought to have initiated would be a suit for declaration, not for the suit of possession, permanent injunction when there is a dispute with regard to identity of property.
Yes, so read the evidence and then you satisfy me on that point. In case of any dispute as to the identity of the property, it is only the declaratory suit.
Declarated. In order, may I continue that?
Please.
23/7/2015. In order to show that I am in possession of suit scheduled property, I have produced Kata and tax paid receipts. Apart from this documents, I have not produced any other documents.
Yes.
Kata certificate is issued by early Gram Panchayat. In this, I pause for a moment. Kata certificate issued by BPMP has not been produced, though they claim that property in subsequent cross examination. Their own plaint, they say that property is within the jurisdiction of BPMP. They don't produce any document issue where BPMP has issued the Kata certificate.
Yes.
Suit scheduled property situated within the jurisdiction of BPMP. It is
Yes.
It is false to suggest that Airoli Gram Panchayat cannot issue Katas and Kata certificate issued, said Panchayat is fabricated. I have fenced the suit scheduled properties from 2004 till now. This point would be important, where he says that I had fenced the property. Further, he disputes that fact when I went to fence, they object. I have produced the layout map in order to show my property. No such layout plan is forthcoming in the entire village. I do not know whether the defendant was allotted 1 acre 18 quotas in survey number 45/3. It is false to suggest that defendant is in possession of the associated property and causing obstruction to the defendant for his peaceful possession and enjoyment. It is false to suggest that except the sale deed, I have not produced any document to show that I am in possession of associated property. Since the defendant had obstructed my peaceful possession over the suit scheduled property, therefore I was constrained to file a suit against the defendant. In the year 2013, when I tried to put up fence around the suit scheduled property, the defendant has obstructed. It is false to suggest that I have filed the suit only in order to grab the property.
Yes.
And may I make a request to my to kindly take exhibit P2, the sale deed.
Take it.
Page number 2 of the document. This sale deed executed by Ramakrishnappa, Lakshmi Hanumantrayappa, Kempanna, Sachidananda in favor of Mukunda. That's the page. Page number 2, madam. In page number 2 of the document.
Yes.
Here there is site as to how the title has been passed through. At para 2, 3, 4, and 5. Because nowhere there's a reference of GPA when we are reciting the title. Further, may I request para 6.
1 second.
Para 6.
1 minute.
para 2, my lords, the recital is to be read.
Hmm.
It is in respect to 4 acres 16 hectares, not with regard to what has been retained by the vendors, excluding the right of the defendant.
Yes.
Para 5, my lords, whereas vendors herein have formed a private layout in the above said property consisting of 64 sites of in various dimensions, and vendors are in joint possession of the same. I make a request to kindly take para 6 months.
Yes.
Whereas on 28/1/2004, the vendors have been executed
Yes.
a general power of attorney in favor of Sachidananda, authorized him to deal with the converted property being survey number 45/3 of Gidatkonenalli, Yeshwanthpur, Hobli, Bangalore, North Taluk, in any manner whatsoever. Whereas vendors have already received the sale consideration in respect to scheduled property from the GPA holder, and also authorized him to collect the sale consideration from the scheduled property from the purchaser. If a sale consideration is been subsequently transferred by the vendors in favor of a GPA holder, there is no document to substantiate that. Whether the vendors were the owner, in what respect and to an extent the property was transferred in favor of the GPA holder is also not forthcoming in the entire state.
Yes.
May I make my lords to kindly take para 9.
Yes.
Whether the sale consideration in respect to this sale deed has passed to the vendor or to the GPA holder. Whereas the balance sale consideration of 94,000 being the loan amount sanctioned by the LIC Housing Finance, and at the request and authorization of the purchaser, the said institution has paid the same to the vendors by its check to sale number in favor of vendor number 4. They claim him as a vendor number 4, not as a GPA holder in the sale. If he has received the sale consideration by the purchasers, his right on the property will have to be adjudicated before granting any injunction by the trial. Because it is not the vendors who has received the sale consideration. It is the GPA holder who has received the sale consideration.
GPA is not produced.
GPA is not produced.
The vendors 1, 2, 3 have not objected for the alleged vendor number 4 to receive the sale consideration.
Para 6, they say that they have received the entire sale consideration and passed on the property to the GPA holder. But no such document has been produced. In pursuance to para 6, para 8 and 9 has been drafted. However, para 8, 50,000, they say that vendor is received. Other vendors have received. Para 6 says that they have received the entire amount sale consideration from the GPA holder and they have transferred all the rights to the GPA holder to receive the consideration. And pursuant to authorization in para 6, para 9 has been drafted.
No, probably in this document, there may be some inconsistencies while describing the parties with their nomenclature as to who are the vendors or who is the GPA holder and whether they have jointly or the vendors jointly through the GPA holder or executing the sale deed. Not clear, but
it may not be inconsistency. For this reasons, para 6, they are very clear that we have received the sale consideration and we have transferred our rights to the GPA holder. That is the reason why para 9, the check drawn from LIC housing has gone to directly to GPA holder. The check which has been encashed.
no. In para 6, vendors 1, 2, 3 have stated that they have received consideration from the 4th vendor shown as such in the sale deed and have authorized him to deal with the property, including selling of the property. Fine. So that alleged 4th vendor, who in fact is a GPA holder, has sold the property to the plaintiff. Some portion of the consideration, according to you, has been received by the so-called vendors 1, 2, 3. Remaining balance amount of 94,000 rupees is in favor of GPA holder. In that regard, can that vitiate the sale deed?
My only aspect is if there's a transfer of right in favor of one person to other person, it could be by way of some instrument, which is not before this court.
That is GPA.
That is GPA. If GPA is covered with interest and if he had acquired the property to sell the property as a vendor, that document will have to substantiate his right to join the sale deed, to receive the sale consideration from the party. Because a third party cannot come as a vendor to a sale deed and receive the sale consideration from the purchasers. With due respect, Manoj, this is the reason why I said there's a cloud in respect to title. Flow of title is concerned. Because the rights which are accrued in favor of the GP holder, nor the 4th vendor who is joined as a 4th vendor, is not been substantiated.
Yes.
Para 9, the mistake.
Yes.
Para 18 of the same reports. At page 4, in page 4.
Yes.
Whereas the vendors 1 to 3 represented by the GPA holder, the vendor number 4 herein have entered into a memorandum of understanding dated 8/4/2004 with Surakshita Properties and agreed to sell site bearing number 1 to 57 in the above said layout, and said Surakshita layout nominated the purchaser herein and requested to execute the sale deed in favor of the purchaser. Whereas Surakshita Properties represented by its partners have also subscribed their signatures to the deed as witness. In this, my early contentions, while execute a memorandum of understanding for subsequent sale with Surakshita Properties, they represent and sell that represented by a GP holder. However, in the sale deed, it is not such scenario. In this sale deed, a sale consideration has passed to the GP holder. So major portion of the sale consideration has been passed, and vendors 1 to 3 say that they have already received the sale consideration much prior to the sale deed, which by way of subsequent documents, nothing is forthcoming and nothing is attached.
No, I am unable to understand. Is that impermissible under law? This is a transaction. Say, I receive some amount from another person, Ramappa. I authorize Ramappa to deal with my property and sell that property to anybody of his choice and receive consideration towards my property from them.
If there is a change of property and the ownership, if I receive the sale consideration and my property is subsequently transferred in your name, or by another persistent, my submission would be there should be some conveyance document which enables him to subsequently transfer.
What he has conveyed under GPA?
That has not been forthcoming. That has not been.
No. What we could make out from this document as to what is conveyed is only an interest, not a title.
If in the sale deed, if a purchaser, original vendors are not received any sale considerations. If a sale consideration in this respect to this property is already been paid, there should be one document witnessing the said sale transactions.
That is between Sachidananda and other three vendors.
Other 3 vendors.
Oh, that is GPA. That is GPA. That point you said GPA is not produced. That will hear from them. But your repeated submission that if the vendors are vendors number 1 to 3, Chikanumaya, Kempanda, etc., and if they have received some amount, executed GPA, how come the GPA holder?
Because in the GPA, there cannot be a transfer of title by receiving the amount. There should be some.
They have not whispered here that there was any transfer of title.
Plus, though in this, whether authorization under the GPA can be given to receive an amount.
Why
and
not?
to transfer the amount.
Why not?
If I have transferred this property, permitting to take the property, it should be GPA coupled with interest, not basically a GPA. A GPA I can authorize on my behalf you collect it. I cannot authorize you collect and you keep it. And I have anyhow received the amount from you. Then it will amount to a transfer.
Whether a consideration in a contract is required to be delivered actually and physically to the promisee alone, or can it be to any person at the desire of promisee?
If that is the situation, there is a shara made in the sale date that sale consideration has been passed at this date.
So probably you are intermixing conveyance, transferring title in a property with that of giving a right to an agent through power of attorney.
Plus, agent can receive a sale consideration on my behalf. He is representing me, Milord.
Hmm.
He will be an agent on my behalf.
Hmm.
He can receive my sale consideration, which will be passed to me
Hmm.
after the sale consideration being received.
Huh.
In this case, it is not so. Sale consideration is received much earlier by that person,
Which person?
the agent. Because a GPA, Milord, if I were to give my GPA to my learned friend, he can receive a sale consideration on my behalf and transfer it to me. It is not just, it is vice versa. I pay a consideration to you, you give me a GPA, I will receive the amount by selling the property.
Whether Sachidananda, in his capacity as a attorney under GPA, is he not agent of vendors 1, 2, and 3?
Exactly, Milord.
Ah.
If he was an agent, he could have received the sale consideration from the purchaser and subsequently transferred it to the executor of the GPs.
The transfer of the consideration from agent to principal, whose concern and whose headache is that?
Plus, it might be a concern of a principal and the agent.
Exactly.
Exactly.
How come you, a third party, a stranger to this transaction, question that?
Plus, dare I say that this would not be a genuine transaction to that end. It would be a concocted or fabricated to grab my land. So the intent,
come to that presumption, please.
Intention of the parties would not be a clear. If a principal gives a power to an agent, agent receives some money, transfer it to principal in all the cases, as my lord said, it is correct. Here in this case, principal receives money much earlier by the agent and agent receives the money from the purchaser.
Yes. Maybe at a maximum, won't it become an agency coupled with interest?
That will have to be established before granting an injunction to them. That point.
No, the very recital here, won't it make that it is an agency coupled with interest?
But however, in this paragraph which has been drafted by para 9, it does not show. He receives the money as a vendor himself. He doesn't receive the money as an agent. If he had received the money as an agent,
I said there must be some improper drafting, but the essence of the deed, when we read all the paragraphs together, para 2, para 5, para 6, para 9, won't it make the picture clear that vendors 1, 2, 3 were vendors who had executed GPA in favor of alleged vendor 4 Sachidananda for some consideration and had authorized Sachidananda to deal with their property, including selling the property and receive consideration. And they had agreed to execute the sale deed in favor of whomsoever the Sachidananda or the firm that has been named therein nominates. As such, the said Sachidananda or the firm, by receiving consideration from the purchaser, nominates them as purchaser. Accordingly, the 3 original vendors, joined by the power of attorney, they have executed sale deed. Is it not in nutshell the summary of this document?
I would slightly differentiate this issue. In normal circumstances, yes, as my lord said. But in this circumstances, Sachidananda, with due respect, my lord, has not joined this document as an agent. He has joined this document as a vendor. If he has joined, what my submission, if he has joined us, this document as a vendor, then you will have to substantiate.
Whether the term vendor excludes agents.
Four. Before. Sale has been defined in section 54.
Neither 54 nor 55 is the executive section say meeting the present problem now.
But also to kindly, what my seniors at 55 to may read that provision itself. What my seniors.
It speaks about the rights and duties of buyers and sellers.
The seller shall be deemed to contract with the buyer. That interest which seller professes to transfer, there should be an interest in favor of the seller to transfer the right and transfer to the buyer subsist, and that he has power to transfer the same. If Sachidananda Malas claimed that he is a vendor and there was a right subsisting to him to transfer the property by way as an agent or as a vendor, first that point will have to be demonstrated to the court. In absence of that, in view of this recitals being made in the CH-8, whether he possessed the right as an agent or as a vendor, and what is his entitlement to receive the sale consideration.
Farooq, don't you find answer in para 6 of the CLD, what you read just now?
Please, that is the reason why I am telling you. If there was an earlier transfer by the vendors in favor of Sachidananda, it should be by way of a document of conveyance which they can transfer. In favor.
They don't call it as a transfer. They have not transferred.
Please, Malas,
Why are you importing that word transfer, convey, transfer? What is not there in this document?
Because they say that the sale consideration has already been transferred.
Yes.
If the sale consideration was not transferred, Malas, I would not insisted on that word. Since the sale, I received the entire sale consideration and gave away my rights to the third party, Malas, to deal with the property as he deems fit. As he deems fit. The agent deems fit, because I have received my entire sale consideration. And once I received the entire sale consideration, the right in the property, when I permit him to deal with the property, the right also is subject matter of.
This is the mute point.
This
is the mute point.
That is like.
In fact, you are also repeatedly using the word right, but not a title. Right might have been passed to the general power of attorney holder, but not the title.
Under which document this right has been shown? How was it permitted for an agent to receive the sale consideration?
The same para 6 says he is authorized to collect the consideration.
That is exactly.
It is there. In the sale deed, it is there.
That is exactly what I read at the first instance. If I transfer my right, which I was holding as a vendor, to a third party by receiving a sale consideration. If I had not, I would pause for a moment. If I had not received the sale consideration before and transferred the rights to an agent, that is a different thing. I received the sale consideration. What title which I had given it to him to deal with the property, and the document does not substantiate that.
The document does not substantiate, but hitherto you are using the word the right have been transferred. Now you are including the title also in that. How come you are importing such a terminologies which does not find place in exhibit P2? Of course, you said GP has not been produced. Yes, that is there. We will see what their reaction
I'll
is.
confine that aspect itself. I'll confine my arguments to that aspect because in the absence of GPA, the fourth vendor would not have been part of this sale deed, nor it would have received the sale consideration.
Yes.
What's the next documents which have been produced? At exhibit P4. The claim substantiate that the property was within the jurisdiction of BBMP. The suit was filed in the year 2013. And this is a demand register of the year 2004-5.
Exhibit P4 shows that it is in Gram Panchayat. Their pleading says that
it comes under
BBMP as on the date of filing of this.
Khata issued by BBMP has not been produced.
Not been produced.
Except P4 and P5 was. And may I make a request number P7. The tax paid receipts produced. This was except Kata number 255. There is no mention as to with regard to the site number. Collectively.
With what description PW1 has produced this document?
To show that he is paid tax.
No, with how he has explained it. Kindly draw my attention to that relevant portion in his evidence.
Para 10 minutes. Para 10 of evidence. verbatim repetition of the claim. There they have said it as document, here they have mentioned it as exhibit, though all these exhibits have not been produced.
Hmm.
They are not, wherever the word document was there, they have mentioned it as exhibits, but all these documents have not been produced, not been marked, which they have mentioned it as exhibits. There's at para 10, which they mention it as taxpayer receipts.
Yes.
As my lords observed in the last occasion, was before registration of Kata, they could have not done this self-assessment tax. But whether this related to the same old property or associated property, there's no explanation forthcoming because this Kata certificate, taxpayer receipts, which have been produced, does not reflect any site numbers.
What is your cross-examination on the said point with PW1? Have you suggested to PW1 that the alleged taxpayer receipts shown to have been issued by BBMP, which are at Exhibit P7 and P8, does not pertain to scheduled property?
Let's
You have not.
Cross-examination.
You have not.
Cross-examination portion 23(7). It is false to suggest that Yerwali Gram Panchayat cannot issue Kata to scheduled property situated within jurisdiction of BBMP. Fifth line notes.
Yes.
It is false to suggest that Yerwali Gram Panchayat cannot issue Kata and Kata certificate issued and the Kata certificate issued by said Panchayat is fabricated. That is only the suggestion we made.
That submission you made, probably that may at the maximum applies to Exhibit P5 and P6.
P5.
With respect to Exhibit P7 and P8, upon which you are now seriously contending that stating that the said tax receipt issued by BBMP is not with respect to scheduled property, there is no whisper in the cross-examination. So you ought to have put at least a suggestion to PW1 to that effect. The witness might have come with some answer. So witness had no opportunity to meet your question or doubt.
And it is also not been explained in their affidavit evidence.
That is different. They have called that these documents pertain to my suit.
I'll have to
We will verify that.
with regard to
But your point, no, the
arguments,
yes,
I'll have to admit that is
not been put to PW1. Yes.
That is not.
Yes.
With P7, P8 and P11.
Yes. Yes. Next point.
Exhibit P15 is the document which is mostly relied by the trial court granted it. My submission would be, this is an ex parte. There's a decree. Whether this is an uncontested suit. Page 12 of the judgment. Page 12 of the judgment.
1 minute. Yes.
Page 12,
Yes.
line number 3.
Yes.
The witness must clear that at para 10 minutes. Last 4 lines, what is instated in the written statement.
Para 10.
Para 10.
Yes.
Last 4 lines, hence dependent number 2 denied the formation of the sites and also denied the execution of PP in favor of Sachinaranda. He has also denied the execution of CH-8 by Sachinaranda in favor of plaintiff's vendor. Para 12, page 12. Line number 3. The witness is not cross-examined in any way. Moreover, the defendants have not turned up to give evidence, hence there is no defendant evidence. Plaintiff has asserted the court. As such, duty is cast upon the plaintiff. That is the there is a decree as against me in respect to site bearing number. This is a different site.
You did not challenge the decree that has
Not
reached
challenge
penalty.
Could be Millers. There would be 2 reasons according to my instructions. Since everything is vacant and this person would have been acquired the property out of 2 acres, 36 guntas which has been acquired by the vendors. This person, since he has not constructed nor tried to put up whatever, this property may not fall into the portion of 1 acre 18 guntas, which this defendant.
No, you are making this submission only on the oral instruction by your client or based on any paper?
Oral discussion.
Oral instruction.
Because there is a decree which I cannot dispute. That is the reason defendant would have not taken any action in challenging this. Because this is the documents produced by the plaintiff to prove their position and right. Before going to the law aspect, may I take my lords to evidence of defendants.
Yes.
I read the evidence from para 4.
Yes, please.
I submit that land bearing survey number 45/3 of Konenalli village, Yeshwanpur Hubli, Bangalore, North Taluk, 4 acres, 15 meters, was earlier belonged to one Patel Andanappa, and he was in possession and enjoyment of the said property. The said Patel Andanappa sold the property of survey number to an extent of 4 acres in favor of my father, deceased Tammanappa. However, at the time of purchasing above said property, my father, deceased Tammanappa, had purchased in the name of minor children Ram Krishnappa, Lakshmi, and Mantrayappa Keppanna on 8/11/1958, who are my brothers, and said CH-8 was registered in Office of Sub-Register, Bangalore, or Telecast. And since then, my father was in possession and enjoyment of the said property. My father, Tammanappa, had 5 children, namely Ram Krishnappa, Lakshmi Mantrayappa, Kempanna, Anmaya, Vairagoda, myself. I further submit as on date of purchasing the opposite property, myself and my brother unnamed Anmaya are not born. However, subsequent to purchase of the said property, myself, my brother Anmaya born Tammanappa, and thereafter we were all also joint possession and enjoyment of the said property along with my brother, that is minor purchaser of the said property. Since from the date of purchase, my father Sri Tammanappa and his children were in possession and enjoyment of the opposite property. In pursuant to the registered sale deed, Khata and other revenue records are located in the name of purchaser. My father, along with my brothers and myself, have been in joint possession and enjoyment of the said property. When such being the case, during the year 1982, at the instance of my father, Tammanappa, my brother, along with me, have division of the properties acquired by my father, Tammanappa, including the property bearing survey number 45/3, measuring 4 acres 16 meters, situated in Konenalli village, Yeshwanpur Hubli, Bangalore, North Taluk, among us, in presence of our father and well-wishers, including in the said partition deed, myself, my brother Lakshmi and Mantrayappa Kempanna have got the share. I have got the share the above said property as per partition deed. Accordingly, I have got share to an extent of 1 acre 18 meters in survey number 45/3 of Konenalli village, for which I have produced an unregistered partition deed. I entered among us my brothers 25/3/1982 for the kind perusal of this honorable court. By virtue of the said partition, I have been in possession and enjoyment of my respective share, but I did not apply the Khata or revenue documents in my name. In the meantime, my brothers named Ramakrishnaya, Lakshmi and Mantrayappa Kempanna got Khata in their names, including the revenue records, by excluding me on the basis of a conversion order passed by the Deputy Commissioner against the said interest. I have made an application to rectify the revenue interest located in the name of Ramakrishnaya and others, as my brothers named Ramakrishnaya and Anmantaya have not at all got any share, not at all got share the property bearing survey number 45/3 of Konenalli village, and they are not at all entitled to hold Khata in their name. Therefore, it is required to be rectified in the said entries on the basis of partition deed affected in the year 1982. One such being the case, I made an application before the Tahsildar to effect Khata into my name by replacing the copy of the partition deed dated 25/1982 to the extent of 1 acre 18 meters in survey number 45/3, Konenalli village, Yeshwanpur Hubli, Bangalore, Taluk, along with other properties acquired by me through partition deed. However, Tahsildar has taken up the proceedings and issued notice to the property parties on the basis of the application filed by me, conducted the inquiry, and thereafter verifying the records placed by the parties. The said proceedings initiated by the Tahsildar, thereby held that passing an order that revenue interest mutated in the name of one Ramakrishnaya and Mr. Anmaya is not correct, as it has mutated on the basis of the conversion order passed by the Deputy Commissioner dated 8/12/2003. Therefore, it is required to be considered on the basis of partition deed affected on 25/3/1982 and directed me to file an appeal before Assistant Commissioner Bangalore to clarify the orders and obtain suitable orders on the basis of partition deed. The said orders passed by the Tahsildar in RRT passed on 30/7/2008 produced for the kind perusal of this honorable court. By virtue of the above said order, I have preferred a revenue appeal before the Assistant Commissioner, wide RA number 294 of 2009-10 against the order passed by Special Tahsildar, and in the said appeal, the Assistant Commissioner directed the Special Tahsildar to effect Khata into my name in accordance with that after issuing notice to the interested parties. Thereafter, the Special Tahsildar closed the RRT proceedings on the ground that said property has already converted, therefore it cannot be registered the Khata in respect share allotted to the partition. Hence, it is said proceedings has been closed without registering Khata in my name. By virtue of the said order, I preferred appeal once again before the Assistant Commissioner against the order of Special Tahsildar. Thereafter, Assistant Commissioner failed to consider the appeal against said appeal. I preferred revision petition wide order 294 of 2011-12, and after verifying the orders and also the documents of Deputy Commissioner as allowed the revision petition by order dated 23/7/2014. The said order copy is produced for the kind perusal of this honorable court. When such being the case, question of right of the plaintiff's vendor, namely Ramakrishna Pashi, Lakshmianantrayappa and Kempana, and other persons have no manner of right, title, and interest over the property that is survey number 45/3, measuring 1 acre 18 hectares of and village, Yeshwanpur, Bangalore, North Taluk. In fact, my brothers have suppressed the actual facts and circumstances, more particularly existence of the partition deed amongst the sons of Tammanna and Tammanappa way back in the year 1982. As such, I have acquired the extent of 1 acre 18 guntas in survey number 45/3 of the village, and since then I am in possession and enjoyment of the said property. Therefore, plaintiff neither owner nor in possession of the property at any point of time, but he and his vendors might have fabricated the documents in order to create third-party interest to knock off my property, and Ramakrishna and others have no any manner of right title to execute site bearing number which is carved in survey number 45 in favor of plaintiff herein, and said it is become void document. I have nothing to do with the same. As on the earliest date of transaction, plaintiff, my brothers, namely Kempanna, are not absolute owners. They are not at all in the joint possession and enjoyment of the said survey number. They have colluded each other, created the sham document in order to grab my property and swallow the sale consideration without having any right, title, interest over the sale. Therefore, plaintiff has to establish as not a date of purchase whether a vendor had good marketable title and free from encumbrances, but he failed to do so, and by virtue of the early sale date stands in his name, does not create any holdings in respect of my property. As such, plaintiff has not in possession, and mere holding the sale deed does not create ownership and possession. The sale deed itself is a sham document, and therefore it has nothing to do with me. And I am in possession and enjoyment of property acquired through partition deed way back in the year 1982. And nobody having any manner of right, title, and interest over the same. In view of such circumstances, interference, etc., does not dispute, and disposition from the same is totally false. And plaintiff has created this story in order to obtain a decree by giving sham documents with an intention to protect the legitimate right over the suit property. Plaintiff is well aware about the existence of partition deed and also my share in survey number 45/3 of Gitkonenali to an extent of 1 acre 18. In this regard, plaintiff and his rowdy elements have come near the property belongs to me, claiming the same other one. But at that juncture, I have shown the documents like partition deed. Proceedings shall be for the revenue authorities in respect to survey number 45/3 Gitkonenali to an extent of 1 acre 18 with that. And after verifying, plaintiff learned that land grabbers might have cheated. At the instant of land grabber, she has filed a false case by creating the dates and events in order to sue against me for permanent injunction. But no such incident has happened. There is no complaint lodged either by the plaintiff or this depend on each other. I submit that there is no cause of action, and the cause of action shown in this paragraph are imaginary, created with an intention to sue against me. As such, no interference either by my side or anybody for the person. Plaintiff was not at all in possession of the respective of the suit schedule property at any point of time. Further, he failed to produce the document to establish that he has been in possession and enjoyment of the same. When there is an absence of the documents with regard to interference and disturbance, I please request the honorable court to dismiss the suit.
Yes. So far, your alleged share in the property, that is to an extent of 1 acre 18 gunta, have you got it demarcated? They have not got it demarcated. So no boundary is fixed for your 1 acre 18 gunta.
As of today, except the orders passed by the new authorities. Since the same has been challenged before this honorable court and it has been stayed. Till now, the boundaries has not been demarcated. Registration of Kata in RA has been stayed by this honorable court and it is pending adjudication before this.
Stayed by this court in which proceeding?
WP. $50,678 of 2014. $50,678. D6.
Yes.
6.
So admittedly, when Kata with respect to 1 acre 18 guntas is not made in your favor.
It has been made in my favor. Third parties have challenged it. It needs to be
Stayed. You are not paying the property tax on the said property.
as on today.
So when the property is not demarcated, you are not quite sure where the plaintiff's property in all these 5 cases comes, whether it is in 1 acre 18 guntas, which is alleged to have been fallen to your share, or in the remaining portion of 4 acres 16 guntas.
Remaining portion of
That is all not clear.
That the identity is still remaining in this case.
Proceed, please.
First, I will take my lord's documents produced on behalf of defendants, then cross-examination of. Shall I read the cross-examination?
Cross-examination I have read it. No need to read it. You can just take me to
The
documents and conclude your argument.
First, exhibit D1.
Genealogical tree,
Genealogical.
probably not in dispute.
Article. Exhibit D2 is a Panchayat Parikat Mulabs. And the RDCs which is standing in the name of vendors and for subsequently Mulabs,
D2 not legible.
I'll file a right. I'll file
This
it.
document is disputed. Probably, yes, they have not admitted the alleged Panchayat Parikat.
Exhibit D2 said they are not aware of exhibit D2, Panchayat Parikat. Last occasion, my friend submitted that I have filed a suit against my brothers and that has been dismissed.
whether exhibit D2 identifies the property with appropriate boundary and measurement alleged to have been gone to your share.
There is no boundaries as such.
Then how?
When ex-
Assuming for a moment that you are entitled for 1 acre 18 guntas out of 4 acres 16 guntas in survey 45/3. Assuming for a moment that that is the fact, still, how can you say that these 5 bits of land in all these 5 suits are the portion of the property that has fallen to yours?
Page number. Connection to the partition. Details. My evidence methods, I have also stated that one of the brothers, 2 of the brothers who have not got share in the property, have also executed as the part as part and parcel of the sale deed. If they have no share in the property, plus the survey will have to be conducted, property will have to be demarcated. 1 acre 18 guntas has been owned by me. In my evidence methods, which I have stated that 2 of my brothers will have no share in the property, has not been allotted share in the Panchayat Park, which they have accepted and
Assuming for a moment that 2 brothers were not allotted with any share, still, unless you pinpoint that I am an allottee of a particular share in a partition, Panchayat Parikat, and that Panchayat Parikat was a genuine Panchayat Parikat, and this is the boundary and area of that bit of land, that bit of property, which has fallen to my share. How can you go against some property merely because that property is carved out of survey 45/3?
I'll get this document typed and make some. I'll get this document typed.
I think you can conclude your argument so that I can hear. Sufficient time has been granted to you.
Type in the paper book, it is typed.
Could read paper book.
Page 82, 83. Sir.
D2 also does not mention about the boundary. The property. Admittedly, the plaintiffs have disputed exhibit D2. They have not admitted exhibit D2.
They say that they are not aware of exhibit.
They have probably, it appears that they have stated it is fabricated and concocted document.
In a cross examination, they are not aware of exhibit.
It is false to suggest that my father has not signed to exhibit D2 and it is not executed by my father and same is fabricated.
But that is a suggestion put to the defendant.
Yes, to you. That is what I said. Plaintiffs have disputed the genuinity and authenticity of exhibit D2. Yes. Any other point?
There's one more, only one submission I'll make and close.
Yes.
Exhibit D4 minutes.
Yes.
What would be the statement of one vendor before the special tahsildar? Yeah, the entire new case has been set up by my Kempada. I read that exhibit D4 is order passed by special tahsildar.
Yes.
Last two lines.
Which page? It runs
First
into
page,
three
first page.
pages. First page. Yes.
ಎರಡನೇ ಪ್ರತಿವಾದಿ ಕೆಂಪಣ್ಣ
1 minute. Yes.
ಅವರ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿ ಕೃಷ್ಣಿತ ಜಮೀನು ಉಪನೋಂದಣಿ ಅಧಿಕಾರಿ ಕಚೇರಿಯಲ್ಲಿ ಸ್ವಯಂ ನೋಂದಾವಣಿಯಾಗಿದ್ದು ನಂತರ ಸದರಿ ಸ್ವತ್ತನ್ನು ಶ್ರೀ ಮ್ಯಾಥ್ಯೂ ಥಾಮಸ್ ಅವರಿಗೆ ಕ್ರಯಕ್ಕೆ ನೀಡಿದ್ದು ಆ ಬಗ್ಗೆ ಒಂದು ಕರಾರು ಪತ್ರ ಸಹ ಅವರಿಗೆ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ಸೇರಿ ಕ್ರಯ ನಿಷ್ಕರ್ಷೆ ಮಾಡಿಕೊಂಡು ಆ ದಿನದಿಂದ ಸದರಿ ಸ್ವತ್ತನ್ನು ಸ್ವಾಧೀನವನ್ನು ನೀಡಿರುವುದಾಗಿ ಮತ್ತು ಕ್ರಯದ ಮೊಬ್ಬಗಳನ್ನು ನಾವುಗಳು ಪಡೆದುಕೊಂಡಿರುವುದಾಗಿ ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ಮ್ಯಾಥ್ಯೂ ಥಾಮಸ್ ಅವರ ನಿವೇಶಗಳನ್ನು ನಿರ್ಮಿಸಿ ಮಾಡುವುದರಲ್ಲಿ ತಮ್ಮ ಅಭ್ಯಂತರ ಇರುವುದಿಲ್ಲ ಎಂದು ಸದರಿ ಸ್ವತ್ತು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಸ್ವಯಂ ಆದೇಶ ಸಂಖ್ಯೆ ಸ್ವಯಂ ಭೂ ಪರಿವರ್ತನೆ ಆಗಿದ್ದು ಸದರಿ ಸ್ವತ್ತಿಗೆ ಮ್ಯಾಥ್ಯೂ ಥಾಮಸ್ ಅವರ ಪರವಾಗಿ ಎಸ್ ಸಚ್ಚಿದಾನಂದ ಅವರಿಗೆ ನೀಡಿದ್ದೇನೆ. So here there's one more plea which has been made by Kempana that they have sold the property to in favor of Matthew Thomas. Matthew Thomas has in turn executed a GPA in favor of Sachidana. That is the reason why the original GPA has not been forthcoming. This order, my lords, conversion order was recommended to be cancelled.
Yes.
And Deputy Commissioner further has, as per Exhibit D8, directed to register revenue interest with the subject matter in writ petition before the Honorable Court. And I have produced one endorsement at Exhibit 9 D9 to state that no sanction plan has been issued by the DB. Irrespective of said, sir. Disregard results. 3D9.
Exhibit
D9.
yes.
Disregard results since dispute with regard to identity. In question was the injunction could not have been granted based on the judgment passed in the other suit. Relying on the judgment passed in the other suit.
Yes.
Since BBMP Kata is not produced, the provisions of section 147 has not been complied. There should be an order registering Kata in the name of the petitioner, which has not been produced before the Honorable Court. Hence, the possession as on the date of filing the suit has not been produced. Proved, and hence he is not entitled for it. Section 147 clearly said an order for registering Kata will have to be done.
That's all.
This 147, I will pass on this relevant portion. It is as per Schedule 3, rules in Schedule 3. Rules in Schedule 3 states that as to how the BBMP will have to register the Kata. Issue a Uttara Patra stating that so and so person is being registered in the Kata. No such exercises has been done in this case. In all other cases, that's verbatim reputation would be the evidence. Schedule 3.
Yes.
Part 1, Part 2.
Yeah.
Schedule 3. For sections 103 to 147. Section 103 to 147 is pertaining to the assessment of property and registrations. No such procedures have been followed. That genuine notes I furnish it after we come.
Consequent both sides present, heard the further argument of level counsel for appellant in full. Since the court time is over for the respondent's argument, followed by reply appeal. List the matter. Agreement notice. On 19. Correct, 2023, and the top of the list. Yes. Yes.
Seal number 65. Vijay Bharat. Pradeep M for R1 R2.
Counsel for the appellant. You are for? Counsel from both sides present, so the court time is over.
20%.
19, second top of the list.
Yes, madam. Yes, madam.
Is the matter.
Last date also, my lordship.
On 19. 7/2023 as the second top of the list.
Number 66. Yes, Satyanarayana Chatke, CGP for respondent.
Not here. List the matter wrong. Twenty. 7/27 on the topmost of the list. It's made clear that no further adjournment to be granted in this matter.
Leading matters.
Other than not reached matter. Yes, please.
38 minutes.
Yes.
Hello, it was listed today for the stage of orders. I had moved the matter to get the interim order extended. What had happened in the matter is respondent number 1, 2, 3 was not served. I have taken steps on the correct address for the executing court. And I have also taken steps for the respected to representing the respondent number 1, 2, 3 minutes in the executing court. The only request is to the interim order may kindly be extended because the appellant has no liability. He was not even in existence.
Mr. Counsel, that order is over. No, this cannot be done. It appears that on the last date of hearing also, interim order was not extended.
No, 38 there was no such it was only today it was for the second time. The other respondents were also served.
I cannot hear anything now because I do not know what is transpired, what order is given. File is not before me now.
In July, the matter is coming to the trial court. The interim order is not extended. Kindly, one number is the even the process is taken.